I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Kim, before we do a sunshine announcement, I do want to welcome our two new members, Councilperson Little and Commissioner Barnaby. Good evening, everybody. You've been sworn in and raring to go, right?
Yes.
I love it. I love it. Okay, sunshine announcement, please.
Yes, Chairman. Good evening, everyone. Today is Tuesday, April 28th in the year 2026. This is a Jersey City Planning Board meeting with a scheduled 5:30 p.m. start time. And in accordance with the Open Public Meetings Act, notice of this meeting has been posted with the city clerk on the city bulletin and posted and left with the city clerk on April 24th of this year. This meeting was also posted on the Jersey City Division of City Planning webpage, and all distribution materials made available to the board were published and made available to the public.
Okay, thanks, Kim. Could we have a roll call, please?
Yes, Acting Vice Chair Gongadin,
Aye.
Commissioner Wick,
Aye, or here.
Commissioner Little,
Aye. Here.
or actually, let me correct that, Councilwoman Little. Yes, that's how we do it.
Either works.
We
Thanks.
stick with council. Commissioner Barnaby. Okay. Commissioner Stamato.
Here.
Commissioner Kaplan.
Here.
Commissioner Patel. And Chairman Langston.
Here.
Okay, we have 8 commissioners present. We have a quorum.
Okay, thank you. Could we swear in the staff, please, Mike?
I see Joe, Matt, Ben, Sophia, Pam. You guys swear any testimony you get tonight is going to be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Okay, thank you. Do we have correspondence, Kim?
Chairman, for the first time in
Come
a long
on.
time, we do not have any correspondence.
All
but
right.
We do have the sunshine announcement marked as B1 in evidence.
Okay, excellent.
Thank you.
So, let's get past adjournments. It's a lot of adjournments. A lot of adjournments. Okay, so let's move right to old business. We'll call item 8 is case P2026-0046 is a one-year extension for 216 Academy Street. Good evening, council.
Good evening, Mr. Chairman, other members of the board, Adam Lazarus of Prime, Duvel, and Maselli. On behalf of the applicant, we are here seeking our first one-year extension for the site plan approval, which I believe expires May 7th of this year.
And what's the reason for the extension?
Primarily, it is that once we had our approval and started going through the construction process, a neighbor did reach out to ask if we wanted to purchase their property. They are in the middle of negotiating that deal. If we were able to purchase that, we would come back for an amended approval to include that property, and if not, then they would go through with the current approvals.
Okay. All right, thank you, council. Any questions, anyone?
No.
Okay, is there anybody here from the public that wants to comment? Anyone from public?
Chair, see no one from the public. I would like to close the public portion.
Okay, motion made and seconded. Public is closed. Matt, anything?
No further comment from staff. Staff recommends approval.
Okay, thank you.
Chair, I'd like to make a motion to approve case P2026-0046 as presented to the board with staff recommendations and conditions.
Second.
All right, motion made and seconded for approval.
Vice Chair Gangadin,
Aye.
Commissioner Stamato,
Aye.
Commissioner Wick,
Aye.
Commissioner Kaplan,
Aye.
Commissioner Patel, Commissioner Barnaby, Commissioner Councilperson Little,
Aye.
and Chair Langston.
Aye.
Motion carries, all in favor.
Thank you very much.
Thank
Have
you.
a good night.
Thank you, council. You too. All right, let's call item 9 is case P2026-0035 as a one-year extension for 30 Newport Parkway.
Yes, good evening,
Good
Mr.
evening,
Chairman,
council.
board members, board professionals, members of the public. My name is Michael Silbert. I'm an attorney at Murphy, Schiller & Wilkes, located in Newark, New Jersey.
Cam, is that mic on? I don't think that's on.
Sorry. Can you hear me now?
Perfect.
Okay. Michael Silbert from Murphy, Schiller & Wilkes here on behalf of the applicant NC Housing Associates, number 200 Co. We are also seeking a one-year extension. We received site plan approval in a memorialized resolution on May 22nd, 2024, set to expire this year, May 22nd, 2026. We, like the prior applicant, we are exploring possible amendments to the originally approved site plan application. We have worked through compliance and are currently working on meeting the permitting requirements under the former approval, but we wanted to provide a buffer in case I believe we are filing an amended application. So we wanted a buffer with our existing approvals while we come back to this board to seek amended approval.
Okay, thank you, counsel.
A
Any
one-year
questions?
extension we are
Sure,
seeking.
1 year.
Yes.
Any questions, anyone?
No.
All right, thank you. Is there anybody here from public that wants to comment? Anyone from public?
Chair, see no one from the public. I would like to close the public portion.
Second.
Okay, motion made and seconded. Public is closed. Cam, anything you want to add? Any questions?
Planning
comments?
staff would just ask that the applicant's attorney agree on the record to the conditions that were placed on the original approval. and
Absolutely.
Planning
Agreed.
staff recommends approval.
Okay, thank you.
Chair, I'd like to make a motion to approve case B 2026-0035 with staff recommendations and conditions.
Second.
All right, motion made and seconded for approval.
Acting Vice Chair Gungadin,
Aye.
Commissioner Wick,
Aye.
Councilwoman Little,
Aye.
Commissioner Barnaby, Commissioner Stamato,
Aye.
Commissioner Kaplan,
Aye.
Commissioner Patel,
Aye.
and Chairman Langston.
Aye.
Motion carries, all in favor.
Thank you.
Okay, thank you, counsel. All right, let's call item 10 as case P2025-0224, our 2 one-year extensions for 16 Van Ripen Avenue. Good
Yes,
evening, counsel.
Good evening, Mr. Chairman, Commissioners. Charles Harrington of Connell Foley on behalf of the applicant. Yes, we are asking for 2 one-year extensions. This project was approved in September of 2022, so with variances, so it was valid through September 2024. So we are asking for these retroactively, which you can request under the municipal land use law. The reason is the property is in Zone 4 in the Journal Square redevelopment plan area. There have been discussions over the last few years of possible amendments to Zone 4 that would then incorporate affordable housing. So this client, along with some others that I have been following those amendments, and they're looking for an extension through September of 2026 to see what happens in that regard with the new administration and council.
Okay, thank you, counsel. Any questions, anyone?
No.
Sorry, I have a question.
Sure, go ahead.
So if the extension were granted, that would mean your client would not need to comply with whatever new requirements for affordable housing might be set forth?
Well, it's
Because they'd be grandfathered, or am I misunderstanding?
Yes, I mean, they would be grandfathered. This is, the approval for 7 stories, 35 units. But with the proposed amendments that have been kicked around, you would have, you would have a larger building with more affordable housing, and I think that's what they're hoping for.
That's what, by they, do you mean the council or your client or both?
Client.
Okay.
Client. Yeah.
And so by granting the extension, we enable that larger building with more affordable housing?
That's right.
Okay,
That's right.
thank you.
Possibly,
Possibly.
Possibly.
potentially, hopefully. I mean, it's not set in
We keep the
stone-
option open.
set in stone that happens, but,
Hopeful.
yeah.
That's right.
Right, thank you.
Okay, any other questions, anyone? Okay, is anyone here from the public that wants to comment on this application? Anyone from public?
Chair, see no one from the public. I would like to close the public portion.
Second.
Okay, motion is made and seconded, public is closed. Matt, do you have any questions, comments, problems?
Staff recommends approval. This is a pretty straightforward extension request. It's, fairly typical for, a development with vested rights to want to preserve the applicability of that application as long as possible if they're not ready to build for whatever reason, be it economic, practical, or otherwise. Staff recommends approval.
Okay, thank you.
Chair, I'd like to make a motion to approve case B 2025-0224 as presented to the board with staff recommendations and conditions.
Second.
Okay, we have a motion and a second for approval.
Vice Chair Gangadin,
Aye.
Commissioner Stabano,
Aye.
Commissioner Kaplan,
Aye.
Commissioner Patel,
Aye.
Commissioner Barnaby,
Aye.
Commissioner Councilperson Little,
Aye.
Commissioner Wick,
Aye.
and Chairman Langston.
Aye.
Motion carries, all in favor.
Okay, thank you. Thank you, counsel. All right, let's call case P2026-0044 as a one-year extension for 216 Palisade Ave.
Okay, again, for the record, Charles Harrington of Connell Foley on behalf of the applicant. Here on this application was approved in May of 2024, and it runs through May of 2026. We are asking for a 1-year extension. I can, represent the reasons for this, and this is an approval for 51 senior housing units, and it had one small variance in connection with the original approval. We are asking for a 1-year extension. My client has been busy with other projects. They are the developer of the Sing Tower, so they have been focused on that. That's the one at the end of Summit Avenue by Route 139. They also would like to have some time to look at this project at possible amendments, and they've had discussions with some neighborhood representatives about maybe some changes as well. So we're asking for the extension to give some more time to discuss that.
Okay, thank you, counsel. Any questions, anyone?
I noticed this is at 216 Palisade Avenue. Is there any connection at all with Christ Hospital, HRH?
No.
Okay.
That's a good question, but no.
Okay,
Yep.
thank you.
All right, any other questions, anyone?
No.
All right, thank you, counsel. Is there anybody here from the public that wants to comment on this application? Anyone from public?
Chair, see no one from the public. I would like to close the public portion.
Second.
Okay, motion made and seconded. Public is closed. Sophia, anything?
Staff asks that the applicant continue to agree to the conditions of the prior approval,
Yes.
as staff recommends approval.
Okay, thank you.
Chair, I'd like to make a motion to approve case B 2026-0044 as presented to the board with staff recommendations and conditions.
Second.
All right, motion and second for approval.
Acting Vice Chair Gangadin,
Aye.
Commissioner Wick, Aye. Commissioner Councilperson Little,
Aye.
Commissioner Barnaby, Aye. Commissioner Stamato,
Aye.
Commissioner Kaplan,
Aye.
Commissioner Patel,
Aye.
and Chairman Langston.
Aye.
Motion carries all in favor.
Okay, thank you.
Okay,
Thank
thank
you,
you.
counsel. All right, let's get into new business. Call case P2025-0225 is a minor subdivision with C variance for 55 to 59 Cater Avenue. Good evening, counsel.
Good evening, Stephen Joseph for the applicant. This is actually a preliminary and final major subdivision with C variances. It's not listed correctly on the agenda, but it was noticed properly. This is a notice case. I do have notices.
All right, thank you.
Thank you, counsel. Did you find one that was wrong? Chairman, I received the affidavit of publication proof of mailing with respect to the application 55 to 59 Cater Avenue here in the city. It does appear to be in order. We're going to mark it as A1 for purpose of the record.
Okay, thank you, counsel.
Thank you. 5559 Cater. This is located mid-block on Cater Avenue between Garfield Avenue, Ocean Ave. It's in the R1 zone. It's a 16,000 square foot lot. We're proposing a subdivision into 6 lots. All of the lots will be conforming with the exception of 4.06, which will be undersized and require a variance for lot area. The other thing you need to know about this is we are minimizing the curb cuts. 3 curb cuts are proposed for a total of 6 lots. Jeff Lewis is our architect this evening. He's going to have some brief testimony to describe the subdivision, and then we have planning testimony from Alex Doherty.
Okay, thank you, counsel.
Yes. Jeffrey Lewis, Jeffrey-Lewis.
Mr. Lewis, good evening. Your license is current in New Jersey tonight?
Yes, sir.
Okay, thank you. You're qualified.
Thank you. Okay, so 55 Cater Avenue is a mid-block oversized lot located between Ocean Avenue and Garfield Avenue. We have the cemetery right across the street from us. We are in the R1 zone here, even though it's currently used for kind of storage space. It's a 16,000 square foot lot. with a width of 150 feet, and then the depth varies a little bit. It's mostly 110 feet deep, but at the end it goes down to 90 feet. And so we are subdividing into 6 lots, each of which are 25 feet wide. So 5 of those lots end up being 25 feet wide by 110 feet deep, so they're a little slightly oversized. However, that 6th lot is 25 feet deep by 90 feet deep. You can see it here at the end here. You can just see how our lot jogs in kind of perfectly at that last 25 feet. So that ends up being 2,250 square feet, which is slightly undersized for the R1 zone. But the one thing I just guess I would testify to is that as an architect, I have designed homes on lots of this size. And it's certainly pretty easy to do without any variances. So we anticipate we wouldn't need any variances to build on this lot.
Thank you, Jeff. If there's no questions for Jeff, we could bring our planner up.
Do we have driveway layouts or anything, council?
We are,
Proposed?
so we're not proposing any of the structures at this time, but we have shown the location of any curb cuts. They're maximum of 10 feet wide, and there's 3 of them for the total of 6 lots. You could see them there centered.
There you go.
Can you just explain what the current curb cuts are in comparison, please?
Sure. Currently, there are 2 curb cuts, one located here and one located here, each for these 2 entries. And so it'll go from 2 to 3.
Okay, Mr. Lewis, I don't know if it shows it on there. What's your distance between the curb cuts?
Well, I mean, it should be 25, 50, 40 feet.
Okay. That was
So-
quick.
Yeah, well, it's 50 feet and 10-foot curb cuts each.
Sure.
We have to do a little bit of math as
Oh, that was
architects.
good. I'm impressed.
So we'll get 2 nice parking spots there.
Okay, perfect. All right, any questions for Mr.
Could
Lewis?
you just comment on kind of, the curb cuts look like they're in the middle of the proposed new lot lines?
Yep.
Just how
That's what zoning's been
working?
asking us to do. So each 2 lots will share 1 curb cut, and they're each going to have their own driveway and garage.
Gotcha. Thank you.
All right, any other questions for Mr. Lewis? Anyone? All right, thank you, sir.
Thank you.
All right, let's bring Alex up for some brief planning testimony. We do want to enter this as Exhibit A1. It's Alex will describe it after he gets sworn in.
Sure.
It's going to be A2.
A2.
You swear any testimony you give tonight is going to be the truth, the whole truth, and nothing but the truth?
I do.
For the record, can you state and spell your name?
Alexander Dougherty, Dougherty.
Good evening, sir. It's been a long time since we qualified you, I think.
Yeah, it's been a couple of years, yeah.
So your license is still current?
Yeah, my licenses are current and good standing.
Okay, did it
yes.
lapse at all in that time? Okay, thank you. You're
Thank you.
qualified.
So before you, not to belabor the board, pretty straight down the middle application, major subdivision to create 6 new lots, as council indicated, and the architect. For this evening, I just prepared an exhibit, 6 slides. It's going to be maps and photographs for orientation and where we are in the neighborhood context here. Slide 1 is a crop out from.
Council, we're going to mark it as A2 for purpose of the record. Does it have a title and a date on it?
It's planning exhibits for 5559 Cater Avenue, Jersey City, and the dates will be the photos I took, which was April 11th, I believe. This
Very
is it.
good.
Yep.
A2, and council obviously will submit that after the hearing.
Yes. So slide 1 is where we are within the respects of the zoning. As you can see, the light gray, we are in that R1 zone. Across the street, the green is a cemetery. Slide 2 is an NJDEP's GeoWeb. Properties outlined in red for a little context of where we are. And really, this map really is just kind of to illustrate the various building footprints and the lots that are out here. As we can see, it's a pretty substantially sized lot, given the context of the surrounding neighborhoods. And again, the Bayview Cemetery across the street. So the next couple slides, 3 through 6, are drone shots that I took myself April 11th. This is what it looks like in real time. And as you can see, there are 3 structures, as the architect indicated, with curb cuts in between. And what we have here is surrounding residential housing. Again, across the street is a cemetery. The next slide is, kind of boots on the ground view. It really is just, your 1-story garage, multiple bay doors. I would argue that there's more than 1 curb cut, that the whole entire property would be 1 curb cut because you have to access the garage doors. The next slide is kind of just a zoom out for context of where we're at within the neighborhood. As you can see, there are a few residential houses to the left of the site, the large parking lot servicing the apartment complex to the right. So kind of just an odd piece in the middle here. And then this is kind of a top-down shot, drone shot, top-down. And really what the purpose of this slide is, that third building off to the right, that weird jog, that's kind of the issue with this subdivision. All 5 of the lots, proposed lots, are clean subdivision. They actually exceed the minimum lot area for the R1 neighborhood housing district zone. And then this one is just slightly smaller. And when I say slightly smaller, it's at 2250, and the requirement is 2500. So it's just slightly smaller. With the R1 zoning district, there is no rear lot depth standard requirement. So it is a little bit shorter. If you look on the architectural plans, it comes in a little bit. But that small deviation, I would argue from a planning standpoint, we can justify under the C2 balancing test, where the benefits as a whole substantially outweigh the detriments here. And before I get started on that, Section 345-41 for the R1 zone, it says the purpose of this district is to accommodate existing housing, encourage compatible infill, preserve the streetscape, and utilize and preserve on-street parking where lot frontage is narrow. So I like to just kind of encourage this idea that we are bringing in a compatible infill. This is a residential neighborhood district. When I comb over the zone, in fact, I would argue that we're most likely, more than not, and I'll kind of defer to the board planners on this, we're getting rid of a non-permitted use in the zone for what is essentially a permitted use, the residential component here. And I say that because point A of permitted uses is first floor commercial, provided that the commercial units existed in the 1930s tax assessor's photos. I don't have clarification if this was here in the 1930s. It's possible. I would probably guess not. But nonetheless, the intent of the R1 zone is residential and encourage that compatible infill. So when I look at the C2, the positives here, project rationale, we reinforce neighborhood scale and rhythm. We create context-sensitive, appropriate infill housing, certainly more efficient use of land, and will certainly enhance the streetscapes and the visual cohesion here. I think this is a really desirable neighborhood. Across the street's pretty quiet, as considering most streets in Jersey City. And then I would argue that, when we talk about the minimal and highly localized block, here it's right in the middle. It's a big section, and we can certainly bring that into scale. I would say this advances purpose A, the public health, safety, morals, and general welfare. The subdivision creates opportunities for modern code-compliant dwellings that meet current fire, building, safety standards. Reinvestment in the neighborhood is certainly reinvestment in the community at large. Purpose E, for appropriate population densities. These 6 conforming residential lots allow for context-appropriate residential intensification as far as fully servicing, the urban fabric and setting. The resulting density is well within the R1 zone's intent and contributes to a balanced, diversified housing landscape. Purpose trees, efficient use of land. The subdivision reuses an existing oversized parcel in an established neighborhood, ensuring efficient land use without consuming new land and expanding infrastructure beyond existing capacities. Purpose I, for a desirable visual environment. These will be new homes, getting rid of that, one-story commercial structure, garage, if you will. Certainly more desirable visual environment within the R1 zoning. Purpose M, really to coordinate public and private development with efficient use of land. Again, this land is here, the infrastructure is here, we can make more efficient use of that, provide for housing. Inclusion, I believe the subdivision meaningfully advances the MLUL, improves neighborhood form, and provides orderly and logical residential opportunities within this neighborhood. The deviation for the lot area, in my professional opinion, is minimal. And we have a parking lot next door, so if there was ever going to be one of our lots that is undersized, I would give it the lot towards the end cap, as we have all that open space, and it's not going to be out of character. But nonetheless, that lot size would not, in my opinion, be visible from the streetscape, as the lots width are consistent in rhythm. So with that, I'll conclude. I do not see any substantial detriment. I see this advancing the R1 and meeting the purposes of the R1 zone, and I think this approval would be warranted on a C2 balance.
Great. Thank you, Alex. That does conclude our direct testimony. This is a major subdivision, so we wanted to make sure we put all the proofs that we needed to on the record. If there's any questions from the board, we're happy to address them.
Thank you, counsel. Any questions for Mr. Doherty? Go ahead.
One question, Chris. Just curious, looking at the survey and this photo, could you just kind of comment where the, I guess, northerly side of your property is with respect to the fence and the pavement?
The northerly side.
Or
of-
the, between lot, if you go to the,
I would argue the northerly side would be.
We
the
could also
parking
bring
lot.
Jeff back up to,
Yeah, bring up his. So the northerly side would be.
towards the parking lot.
or towards the left of this
Yes,
image.
towards the left
Yeah.
of the exhibit.
Yeah, just curious, like where your property line is versus lot 3 compared to the built environment. I think if you go lower, you were showing.
So I would say it's, property line is probably pretty consistent with the fence line, but I'm not a surveyor.
Existing survey?
Yeah.
Yeah.
Existing survey will be clear.
Okay, here we go.
That's what you want to see. If you have some space there.
Yeah.
Jeff, can you just comment on that briefly, maybe?
Sure. So right now, the existing building that we're showing on the left of the drawing here is, it looks like between 5 and 10 feet off of the property line until it gets to the back, and we are right up against that back property line.
Yeah, and you could see the adjacent the apartment building at the bottom of the exhibit as well, where that building comes out.
Gotcha. But there is a space, in this case, to the left between tax lot 3 and your property line that is asphalt pavement currently of the current stucco frame building, but is on a different property?
So to the left here, what they have is their parking lot here, and then
I
here
see.
there's a curb and a little bit of a planting area, it looks like. Or is that the macadam area? I'm sorry, that's macadam actually.
Macadam.
But there is a curb, and then it's up a little bit. I think you could probably see that in your picture, right?
Yeah.
Yeah, that's this right here. So our property line is right in the middle here.
Inside there. Okay. Just a little odd, but all good. Thank you.
So,
Okay.
Commissioner, I don't think the fence demarks the property line. I think the fence demarks where that curb is, because I believe there's a change in elevation. And
That's
it's
correct.
probably to prevent anybody in that parking lot from.
Makes sense. That explains it. Thank you.
I think one of the more noticeable improvements we get to pull those 3 structures off that rear property line, because it's my understanding right now they're going back to the rear property line up there. So there's residents behind us. We can, kind of pull those properties off that line.
Okay, thank you. Any other questions?
Structures, yeah.
Okay, thank you, sir. And counsel, that was your presentation?
That does conclude our direct presentation. Thank you.
Okay, thank you. Is there anybody here from the public that wants to comment on this application? Anyone from public?
Chair, still no one from the public. I would like to close the public portion.
Second.
Okay, motion is made and seconded. Public is closed. Matt, do you have anything you want to add?
Staff substantiates and agrees with Mr. Doherty's testimony regarding the C2 test for the variance. This is in the R1 neighborhood housing zone. The very typical typology in that zone is your typical 25 by 100 foot lot with small neighborhood scale housing. That's copy pasted all over Jersey City. It's your standard residential fabric here. The applicant's proposal takes what is a sort of a pre-existing non-conforming deviation from that pattern and is re-subdividing the land to continue that pattern. And in that sense, it's advancing the purposes of the district itself, the purposes of our LDO, and our municipal land use law. As Mr. Noyles testified, that non-conforming lot, you will be able to build a conforming structure, so they wouldn't have to come back and go in front of the zoning board for a variance to develop that lot. The rear yard is set in our zoning code as a percentage of the lot depth, and so the required rear yard scales with the size of the lot. So there's no situation where our zoning code presupposes that you're supposed to have 100 feet back there, and there's no geometric conflict. Staff prepared a memo dated April 9th, 2026. Staff just requests that the applicant agree to the 2 conditions within the memo.
Yes, the applicant agrees. Believe there was also a forestry memo, if I'm not mistaken.
Correct.
So those, we will work with forestry on addressing their comments as well. So the conditions in the staff report, together with the comments from forestry, which is undated, but
Yeah.
we acknowledge them and we'll work with forestry
Yeah,
on
the
addressing those comments.
yeah, the substance of that memo is essentially to, you know, if and when these lots are developed, we would trigger street tree requirements here. You've left adequate space between the curb cuts to provide for conforming tree pits, which just with regards to the offset shared curb cuts that Commissioner Kaplan brought up, so that is not only preferred by our zoning code, but it's actually in a situation like this, it's the only form of curb cut and vehicular access allowed, and that's in order to preserve on-street parking. So previously, you know, normally you cannot have a curb cut and off-street parking on narrow lots like this unless you're doing a shared curb cut configuration such as the applicant proposes. And with that, staff recommends approval with conditions.
Okay, thank you, Matt.
Chair would like to make a motion to approve case P2025-0225 as presented to the board with staff recommendations and conditions.
Second it.
Okay, motion is made and seconded for approval with conditions.
Acting Vice Chair Gongadin.
Yeah, based on the variance requested, I don't feel that it's any detriment to the general public, so my vote is aye.
Commissioner Stamato.
I'm in favor of it.
Commissioner Kaplan.
Aye.
Commissioner Patel.
Aye.
Commissioner Wick.
Aye.
Commissioner Councilwoman Little.
Aye.
And Commissioner Barnaby.
Aye.
Motion carries, all in favor. Oh, and Chairman Langston, my apologies.
Okay, fine. I had a whole speech prepared too, Matt. So, yeah, I agree with Mr. Doherty's testimony. I think he's spot on here. There's, you know, falls onto the C2. There's no detriment to the zone plan, the master plan, and certainly the benefit of, you know, losing that full site-wide curb cut is definitely a benefit to the community. So my vote is aye.
Motion carries, all in favor.
Okay.
Thank you.
Thank you.
Have a good
everybody.
evening. Mr. Chairman, while I'm up here, there are two matters at the end of this agenda, which I am told will not be reached this evening while I'm here.
You're welcome to stay, council. I don't know that we don't make them or not.
I'd almost encourage you to stay, Council.
My professionals on those are not here this evening, as they concurred with that opinion. So I would like to carry those two cases this evening, which are
21 and 22.
21 and 22, 662 Communipaw Avenue, P2025-0032, and 3032 Waverly Street, P2025-0127.
I think that's August.
Council, actually, we were going to carry with preservation of notice to May 12th.
That's what I was told.
Yes, we're going to try and carry with preservation of notice until we can't carry with preservation of notice anymore.
Okay.
Yeah.
All right.
Okay, so once again, case number P2025-0032, preliminary and final major site plan with C variances for 662 Communipaw Ave, will be carried to a date certain, May 12th, with preservation of notice. And case P2025-0127, a minor site plan with C variances for 30 to 32 Waverly Street, will be carried to a date certain, May 12th, with preservation of notice. Anyone from the public, just, you know, for information purpose, if you're here for either of those applications tonight, you will not receive new notice. This is your notice that we will hear them possibly on May 12th, but you will not receive new notice on those applications. Okay, thank you, council. All right, let's call item 14. This case P2025-0180 is a minor subdivision with C variances for 113 to 115 Oak Street. Good evening, council.
Good evening, everyone. Michael Higgins, Castano Quigley Cherami for the applicant. I have the proof of notices here, if I may approach.
Please.
Counsel, is there or is there not a variance on the application?
There is a side yard variance. For the side yard setback.
I don't see it here, Counsel.
Okay. Understanding that there's a clerical issue with this notice, it seems, we're going to have to look into that and come back. So I'd request that we carry until the next available meeting.
I think you're going to have to renotice
Yeah,
it.
you're gonna have
Can't
to
we put it on the
renotice,
12th?
Counsel.
Yes.
You'll have to renotice. You'll have to work with staff on coordinating that time and date. At this time, it would be adjourned to a date uncertain.
Yeah. Okay. Thank you, Counsel. Okay. All right, so this one's different, everybody. If you're here for that application tonight, we're not hearing it, there's a problem with the notice, you will receive new notice. So we don't have a certain date that we're gonna hear that application, but if you're here for that, you will receive new notice. So moving on, let's move on to item 15. Is a minor subdivision, case number P2025-0131, minor subdivision for 61 Prospect Street. Mr. Burke, good evening.
Thank you, Chairman. Good evening to all. Jim Burke representing the applicant. It is a minor site plan. There are no variances in this matter. And I'll just state for the record, there's a curb cut existing which will be closed up. This was carried from another hearing, all right? So we did notice for that hearing, so hopefully we're in good shape. And with that, I would just bring up my surveyor.
Okay, thank you.
So, Mr. Burke, for purpose of the record, the notice was marked as A1, so.
Thank you, counsel. Oh, yeah. No, I'm sorry.
It's Valery Braginsky. And spell it? Valery, last name B as in boy, Raginsky.
Yeah, same here. I don't know why you didn't have it. Good evening, sir. You're licensed in the state of New Jersey?
I am.
And that license is current tonight and in good
It is.
standing? Okay,
It is.
thank you. You're qualified.
All right, thank you. So just to briefly walk the board through the proposal and state, if you would, the current configuration and what's proposed.
So currently there's a three-story dwelling on the property. It's a 50 by 100 foot lot. We're proposing to subdivide the property, a minor subdivision, into two 25 by 100 foot lots, and proposing to demo the building and remove the curb cut that's currently in front of the property.
And I stated on the record there are no variances. Can you confirm that?
Yeah, there are no variances for either proposed lot.
I'd like to stretch the soup, but I don't need to.
Good. I think we have enough. All right, thank you, sir. Any questions, anyone?
Yeah, after the building is demolished, what is the proposed use?
At this time, they have not proposed any use. My guess from speaking with them, it may be something coming in which are conforming structures.
But that's not in front of us tonight, so we're
Okay.
strictly hearing the subdivision and the removal of the curb cut.
Okay.
If any relief is needed, the board, a new application would have to be submitted.
Okay, any other questions, anyone?
No.
All right, thank you, sir. We appreciate it.
You can sit because we're.
Well, let's finish
Yeah,
this.
I know
Council,
that.
that's your presentation now?
Yeah, but I don't want them to leave.
No, me neither. So that's your presentation, nothing else?
Yes, that's
Okay,
it.
thank you. So is anybody here from the public that wants to comment on this application? Anyone from public?
Chair, see no one from the public. I would like to close the public portion.
Second.
Okay, motion is made and seconded. Public is closed. Sophia, floor is yours.
This is a straightforward subdivision with no variances. There's not much to comment. Staff does ask that the applicant agree to the conditions in the memo dated March 24th, 2026.
The applicant agrees.
Okay, staff recommends approval.
Okay, thank you.
Chair, I'd like to make a motion to approve case B 2025-0131 as presented to the board with staff recommendations and conditions.
Second.
Okay, we have a motion and a second with conditions for approval.
Vice Chair Gangadin.
Aye.
Commissioner Wick.
Aye.
Commissioner Councilperson Little.
Aye.
Commissioner Barnaby.
Aye.
Commissioner Stamato.
Aye.
Commissioner Kaplan.
Aye.
Commissioner Patel. And Chairman Langston.
Aye.
Motion carries all in favor.
Okay, thank you. So let's call item 16 as case
Thank
B
you, Ken.
2025-0128 is a minor subdivision for 231 New York Avenue.
Thank you, Chairman. Same situation. It's a minor subdivision, no variances. I'm going to hand counsel the notice because this is the first night we were scheduled for this matter.
Chairman, I received the affidavit of publication proof of mailing with respect to the application. It's 229 New York Avenue here in the city. It does appear to be in order. We're going to mark it as A1 for purpose of the record.
Thank you, counsel. Go ahead, Mr. Burke.
Perhaps the witness needs to be sworn in again. Oh, you good?
No,
Okay.
he is sworn, but let's just note for the record that he has been sworn in, and I'm assuming did not lose your license since the last application, so you are still qualified, sir? And are under oath.
For the record, just state your name again, sir.
That's Valery Braginski.
Okay, thank you. Go ahead.
Now, in a similar situation, there was a curb cut. There is an existing curb cut, and that will be closed, correct?
Correct.
Okay. And so just give the board a summary of what the lot is now and what the lot will become.
So currently, there's a 2.5-story dwelling on the property, 50 by 100 for this property. We're proposing to subdivide into 2 lots, 25 by 100 each. No variances proposed or needed in the 2 properties, and the existing curb cut will be removed.
And again, we'll stipulate if the, when the owner proposes to build something, if a variance is needed, then a new application will be submitted.
Okay, thank you, counsel. Any questions, anyone?
No.
Okay, thank you. I do have to note for the record that this is my neighborhood, but I am slightly outside of the 200-foot mark, so I'm able to vote on this application. Okay, counsel, that's your presentation?
Yes.
All right. Is there anybody here from public that wants to comment on this application? Anyone from public?
Chair, see no one from the public. I would like to close the public portion.
Second.
All right, motion is made and seconded. Public is closed. Ben, you have anything you want to add?
Yes, upon review, it appears that the proposed lots do adhere to the standards of the R1 zone as written, and there are no variances associated with this proposal. The application advances the purposes of the R1 zone by encouraging compatible infill, excuse me. and staff recommends approval, provided that the applicant agree to the conditions in the staff memo dated April 28th, 2026.
The applicant agrees.
Great. Staff recommends approval.
Okay, thank you.
Chair would like to make a motion to approve case P2025-0128 as presented to the board with staff recommendations and conditions.
Second.
Okay, motion is made and seconded for approval.
Vice Chair Gongadin,
Aye.
Commissioner Wick,
Aye.
Commissioner Councilperson Little,
Aye.
Commissioner Barnaby,
Aye.
Commissioner Stamato,
Aye.
Commissioner Kaplan,
Aye.
Commissioner Patel,
Aye.
and Chair Langston.
Aye.
Motion carries, all in favor.
Okay, thank you.
Thank you, and I appreciate the courtesy of putting them back to back.
No worries. Okay, I think, Mike, do you want to break now, just so we don't have an interruption a half hour from now for a break? So we are going to take a break right now rather than taking it at 7 o'clock. But we will, as soon as we get back, we'll hear case P2024-0182 is a preliminary and final major site plan and interim use for 200 Chapel Avenue. Okay, be back in 10, everybody. And we'll call the next two items. Case P2024-0182 is a preliminary and final major site plan and interim use at 200 Chapel Avenue, as well as case P2024-0229 is the review and discussion of master plan amendment within Caven Point redevelopment plan. Council, take it away.
Good evening, all, and good evening to the new commissioners. Nice to have you here. My name is James McCann from the law firm of Connell Foley in Jersey City. I'm here on behalf of the applicant, Pulte Homes, in both of the applications that were called. I think before we do
Let's get council's appearance on the record.
I was going to say, let's
Let's
do some housekeeping.
Make sure everybody's eligible.
Good evening, Chairman, and
Good
the rest of
evening,
the members of the board. My name is Martin Cabalar, attorney with Becker NEPC. We are counsel for Port Liberty Homeowners Association Incorporated. It is a neighboring property homeowners association, and I'm representing them as an objector in this case.
And we do have another attorney of record, so. Counsel?
Yeah. Good evening, commissioners. My name's Cynthia Hagianis. I'm here representing Port Liberté Condo Association Number 1. It is one of the 3 condo associations within the umbrella association represented by Mr. Cabalar. There's about 415 units within that condo association Number 1. Thank you.
Thank you, Council.
Welcome, counsel. So for everybody in attendance, members of the board, both of the attorneys have been participating. Ms. Hagianis has just recently come along into the case. Mr. McCann and Mr. Caliber have been here throughout the duration of the hearings. We do have some new board members. We have some board members perhaps that had not participated live. So can we just go over who needs to attest that they've listened, watched, and or read the transcripts and are eligible to vote?
So we would have to confirm on the record that our 2 newest members have read and or watched the previous testimony.
I have read the transcriptions.
Same with me.
Okay.
But I also think that
I also can attest that I have also watched and read them.
Thank you.
And there's still a few more. I did miss one of those meetings. I am up to speed. I've watched the video, and I would vote on this application tonight. And what else do we have here, Cam?
So the only other thing I think that needs to be stated for purpose of the record, Mr. Stamato has left the dais, he's left the building, and he has recused himself from this application. So let the record reflect that not only has he recused himself, but he has left the building for the evening.
And Vidya, I believe you missed one meeting.
I believe it was in the
August
meeting.
12th.
And subsequently, we had another one after that. So I did watch and read the transcript.
Okay, thank you. Gold star, Liz. You were at all of them. Gold star. Okay, Council.
So
I think we're
confirming
up to speed.
everybody's read the transcripts or watched them and is familiar with the case at this point?
Yes, correct.
Okay, thank you. All right, so just a brief introduction. This property is 200 Chapel Avenue. It's block 27503, lot 15 on the Jersey City tax map. It's a 9.5 acre portion of land. It is between the Port Liberté community, which is represented by the other two council who have appeared here, and it is adjacent to the Liberty National Golf Course. The property is vacant land, except for an MUA pump station, a garbage dumpster that is immediately off Chapel Avenue, and a temporary dog run at the rear of the property. It is in the Caven Point redevelopment plan. The proposal before the board previously and tonight is 168 stacked townhome-style condos situated in 19 four-story buildings. Each unit will have 2 parking spaces, one on a driveway, one in a garage. The development also has 80 guest parking spaces. As the chairman mentioned, the application is for the initial one on case 182 is a preliminary and final site plan approval with an interim use approval to have a sales trailer on the property for 3 years. So testimony was taken initially in this case on May 27th, 2025. The case was continued during the summer. There were procedural motions made by both sides, and testimony was then again taken on September 9th of 2025, and testimony by Pulte Homes' civil engineer, their project architect, and their traffic expert. And at that time, the Homeowners Association was already involved in the case, and they were already submitting comments to the applicant's plans to this board and to the applicant. And so when we testified at the September, when my experts testified at the September hearing, we had said we had addressed some of their comments, but due to time constraints, we had not been able to address all of their comments. They were under consideration. We had also told you that we had addressed many comments from the Department of Infrastructure as well as the MUA, but there were still comments to be dealt with. The hearing ended that night. There was cross-examination by the HOA. The case was carried with preservation of notice, and the next time we appeared before the board was on October 28th. And what we had told you at that time was that between the September hearing and the October hearing, we had the opportunity to address many more comments of the Homeowners Association as well as the review agents that were participating in the application. However, we did not have testimony that night because there was a procedural issue, so the case was carried with preservation of notice again. It was carried a number of times over the winter with preservation of notice, and now we're back here to continue testimony. What we're going to show you tonight are a new set of plans that were filed with the Planning Division in this board in October of 25. And those plans do their best to address the issues that the Homeowners Association has with the project, as well as they address comments from Department of Infrastructure, and there's an arrangement made with the MUA to make some improvements on this property for the purpose of sanitary sewer pump station. So we're going to show you what we've done. We're going to introduce a new set of plans. I have 3 witnesses: the project traffic consultant, project engineer, and the project planner. So my first witness is Mr. Carl Penke, the traffic expert.
So council, before we get to that, let's just do some further housekeeping. So, sir, you can have a seat. It's probably going to be a little bit of time before we get to you. Specifically, council, I am up to and have marked A14th, which was the Langen traffic study, last dated September 6, 2024. Is that
Yes.
accurate?
Yes, I can tell you that we have exhibits A1 through A14, which we've collated. I think they're posted on the portal, I'm not sure, but we sent them into planning. They were all documents that were introduced and marked at the hearings, either in May of 2025 or September of 2025.
Now, council, I received a letter from Objectors Council dated April 21st, 2026. Did you receive that letter as well?
Is that the letter that questions the or raises the expiration issue of the redevelopment plan?
It is.
Yes, I received that letter.
Okay. So I think it appropriate that we start there. Council, if you want to be heard on that, we'll hear you on that first.
Thank you, Council. Mr. Chairman, fellow commissioners, good evening. As you know, the applicant has introduced in its submission Exhibit A5. That's the Cavan Point redevelopment plan. Last revised October 13th, 2022. And that is the basis on which applicant's application is based. That redevelopment plan, as explained in the memorandum that I submitted to the board, has an explicit expiration date of 40 years from adoption of that plan. Now, while I understand that the board's planner has advised that there is no authority that permitted the city council allegedly to put an expiration on the redevelopment plan, that is really a legal matter, particularly as there's no authority which prevents the city council from putting in such an expiration. To the contrary, the law and the case law interpreting it supports the authority of the city council to put in such an expiration, as was done here. So given this, prior to this hearing tonight, about a week ago, we submitted a legal memorandum on this point, which I provided to your council, to your planner, and I would like to mark that into the record as Exhibit 01, if that is okay with the board.
So, Mr. McCann, I have no issue with the letter being marked as 01 for purpose of the record.
Mr. Calabar's letter, I have no issue with that.
Okay, so 01 is the Calabar letter dated April 21st, 2026.
And council, are you going to read that letter into the record, or?
I'm not going to read into the letter. I'm going to make the argument before the board what is in that letter, essentially highlight the key points for you. You will obviously have a copy of that record. If you want to go back and you want to see a copy of that letter to see what's in there, ask your counsel about it. Anything of that nature, you have it before, you'll be able to do so. That's the intent of marking it.
Council, give me one quick second, please.
Sure.
Yes, we're comfortable without having been given the opportunity of the board members to read the memorandum.
So let me ask my questions on record. I haven't seen the exhibit. The board hasn't seen the exhibit. Council, I welcome your highlighting the key points for us, but I think we should see the letter.
Do you want? I have copies of it, which you can certainly
Sure.
have.
If you want to read the letter, absolutely. Council can pass it around. It's a legal memorandum of council's position. I have them.
Thank you.
So just to highlight some of the key points in the memorandum and really talk to you about what this issue is. The redevelopment plan has a very explicit provision that reads, "The provisions of this plan specifying the redevelopment of the project area and the requirements and restrictions with respect thereto shall," quote, "shall be in effect for a period of 40 years from the date of approval of this plan by the City Council of the City of Jersey City." That language is pretty clear. There's no ambiguity there. It says it shall expire. That's a mandatory limitation of 40 years from adoption. Local redevelopment and housing law, pursuant to that, these plans are adopted by ordinance. That means they carry the same force as the law. It means they have to be enforced by the municipality. The plan was adopted November 7th, 1984. No one can reasonably disagree with that. It says right on the plan, that's when it was adopted. None of the amendments to the plan altered, changed, extended, or otherwise impacted this explicit 40-year sunset provision. No one can reasonably disagree with that. At no point in time was the redevelopment plan readopted. No one can reasonably disagree with that. And you can discuss this point with your council, but as cited in the case law in our memo, redevelopment plans are legislative instruments, and therefore they can be revised, they can be amended, and they can be abandoned, as this sunset provision does, as adopted by the City Council. The issue here is not whether there is any implied expiration date or applied extension even. The express legislative language of the redevelopment plan was to implicitly and directly include a time limitation. The city, the planning board, legally bound to honor that limitation. The City of Jersey City cannot, on the one hand, select provisions of a legislative enactment and at the same time ignore other provisions. You can't ignore this 40-year expiration. I want to be clear about something in our position. This is not a request for the planning board to impose some temporal limitation. It's simply a request to enforce the law, the limitation that Jersey City itself enacted when it adopted the redevelopment plan. There's no question that the plan expired on November 7th, 2024. None of the amendments extended the expiration date or otherwise revived the redevelopment plan. Because of that, and I mean this with all due respect, but because of that, the planning board lacks authority to consider the application. The application is based on the redevelopment plan. The redevelopment plan has expired. Any hearing would be premature and should be deferred unless and until the city adopts a new or readopts or amends this redevelopment plan. Now, you will also recall that you heard from Councilman Solomon on this issue, how it is the regular practice of the council to adopt sunset provisions because it properly serves as an enforcement mechanism to reassess zoning and redevelopment plans after 30, or even in this case, as he stated, 40 years. As members of this board, if you agree that the redevelopment plan has expired, then that alone is a basis for you to vote to deny this application right now at this time. You need not wait until the matter is concluded, and you need not continue to waste what we believe is precious municipal resources. So with that, thank you for your time on this issue, and if you have any questions, I'm happy to answer them.
Okay, thank you, counsel.
Thank you.
Got to give Mr. McCann an opportunity.
Sure.
If you don't have questions.
Mr. McCann?
So it's going to take me a minute because I have a few exhibits that I'd like to show the board as a rebuttal to this.
Okay.
Carl, I think you can sit down.
Sit down.
You advance it first, though. How do you advance? Keep going. You keep going as much as you want. Got it. Yeah, thank you. Cameron, can we, okay, thank you. All right. In response to the HOA, Council, you want to ask a question first?
Go ahead, counsel. Let's go through your
Okay.
position first.
So, there's a process here that's been followed by the City of Jersey City by the Planning Board of Jersey City, not the City of Jersey City, because this is about the Planning Board. There's a process that's been followed by planning for 5 years now. And what I did on behalf of the applicant was obtain a zoning determination from the Jersey City zoning officer asking for an interpretation of whether the Cave-In Point redevelopment plan expired. And I provided the zoning officer with a fee, which you have to do. I wrote a letter, and that letter was submitted to the planning board, to the zoning board, the zoning officer. And the response that I got from the zoning officer is posted on the screen now. It's a formal zoning determination from the Jersey City zoning officer stating that the 40-year expiration period does not invalidate the zoning regulations of the Cave-In Point redevelopment plan. The zoning regulations of the Cave-In Point redevelopment plan survive the 40-year expiration period. Now, that letter is part of a procedure that starts out with the New Jersey Municipal Land Use Law. Because under the land use law, the zoning officer is the first stop if a property owner or an interested party or anybody has a question regarding the interpretation of a zoning regulation, which is exactly what a redevelopment plan is.
So, counsel, for purposes of the record, I want to mark it as A15.
And I was getting there, but this letter has been posted on the portal since November of 2024 as part of our application.
So this is the November 12th, 2024.
No.
Zoning officer determination.
And we're marking it as A16?
A15.
A15, right. So
Mr.
why
McCann, before we, because I want to keep this clean. I thought I saw it on the portal. Did you also submit your letter requesting the determination by the zoning officer?
I did not.
Okay.
I have a copy of it somewhere here. I could tender it as an exhibit if it pleased the board.
It's your case, counsel. If you want it in the record, we'll
It
put
doesn't
it
need
in
to
the
be, I
record.
don't think, no.
Okay. So that's A15. Continue, please.
Okay. So why is this letter significant? Because as I said, under the MLUL, the zoning officer is the first stop for the interpretation of a zoning regulation. So the applicant followed the law. They wrote a letter to the zoning officer and got the zoning determination. Now, once that determination is issued, my client, whether they got the result that they want or the reverse result, they're bound by that. Taxpayers are bound by it. Politicians are bound by it. The city of Jersey City is bound by it. Any interested party in this case is bound by that zoning determination. Now, and that's because the MLUL says so. And so does the Jersey City Land Development Ordinance, by the way. There's provisions in that in the ordinance for the procedure that I just described to you. So now that letter can be appealed. The place it gets appealed, if there is an appeal, is to the Zoning Board of Adjustment, not to the Planning Board. Why is that? Because the municipal land use law says that if there's a question regarding a zoning interpretation from a zoning officer, it should be appealed to the Board of Adjustment. The Land Development Ordinance in Jersey City says the exact same thing. You appeal to the Board of Adjustment. Now, this letter has not been appealed by any interested party. So as of right now, it is valid in full force and effect, and this board is bound by it. Now, this is a letter from the zoning officer. But if you look at the screen, you can see that the letter refers to a zoning Board of Adjustment decision. Because this is not the first time this issue came up. This issue came up in 2021, where on behalf of an applicant, I wrote a letter to the zoning officer asking for a determination as to whether the village redevelopment plan in Jersey City had expired or whether those provisions, the zoning regulations in that redevelopment plan remained in full force and effect. In that case, the response that I got was the exact response that Mr. Calabar is suggesting, that the redevelopment plan had expired, so my client could not proceed with a site plan application that was before this board. The planning division staff stopped my application, told me I could not proceed. So I went and I wrote for the letter. I wrote and got the letter from the zoning officer in that case. Now, in that case, the zoning officer said exactly what Mr. Calabar is suggesting. However, I followed the law of the city and I appealed that decision to the Zoning Board of Adjustment. And the Zoning Board of Adjustment reversed the decision of the zoning officer in that case, in the village case, and determined that redevelopment plan zoning provisions do not expire. They remain in full force and effect despite the expiration of the term in the redevelopment plan. Now, keep going. This is that decision. This is the decision in the 303 First Street case. And I presented an argument with the professional planner before the Board of Adjustment, who is charged with overseeing decisions of the zoning officer. The board, the full board was there. The board's attorney was there. Legal arguments were made. And in this case, in the village case, the board determined, as I said, the redevelopment plan zoning regulations remain in full force and effect. It may be that other components of the plan have expired, such as the right to condemn, such as the right to give tax abatements, but the zoning regulations remain in full force and effect. So the letter that I obtained for this case relies on the Zoning Board of Adjustment case. And when the Zoning Board of Adjustment makes an interpretation of a redevelopment plan and a zoning regulation, my client was bound by it regardless of which way the decision went. All the taxpayers were bound by it, and there were people there that commented. The planning division is bound by it, and this board is bound by it. Because under the MLUL and the Jersey City Land Development Ordinance, it's the Board of Adjustment that has the power and authority to make these kinds of decisions. Politicians are also bound by it. Councilman Solomon at the time is bound by it. So when I'm standing here, and I will point out to you that the planning division in this case has allowed my application to move to completeness, and we've presented our case. We've already started our case in May. So the planning division has not taken any action to stop this application from moving forward. So I'm relying on the zoning officer's determination based upon the Board of Adjustment's decision. And that's the way this should be. That's the way the MLU works, and that's the way the Jersey City Land Development Ordinance works. And until that decision is appealed to a higher authority, it's the law of the land in Jersey City, and it must be followed by everybody in this room. Now, there's some good reasons why the Board of Adjustment came to that conclusion. I'm not going to go through them all because I'm relying on the determination and the decision of the Board of Adjustment, but next page. One more, that way. Keep going. Keep going. One of the reasons the Board of Adjustment ruled the way that it did is because the municipal land use law at section 90 says that moratoriums imposed upon development so that zoning ordinances can be amended is not permissible. It couldn't be any clearer. That's the municipal land use law up on the screen in front of you. So section 90 says exactly contrary to what Mr. Caballar said. He said that you can't hear this case because the redevelopment plan expired. You have to hear this case because the board can't impose de facto moratoriums on development to give the city council a year, 2 years, 3 years to either amend the redevelopment plan or change the zoning. That's one of the reasons the Board of Adjustment came to the conclusion that they did. There are other reasons too. Another reason is that in 2001, the Caven Point redevelopment plan was incorporated into the city's zoning map as the permanent zoning for this area. When the city adopts its zoning map, anything on the map becomes part of the zoning ordinance. That was the other reason that the Board of Adjustment made that ruling. So there's a lot of reasons and there's a lot of process. It's not as simple as saying the 40-year expiration period has passed. There's much more to it than that. And I'm asking you to, I will tell you this, the 303 First Street case, after that zoning determination by the board was given, by the Board of Adjustment was given, this board approved the site plan application for it. Only a few months later, this board honored that Board of Adjustment decision, and I can tell you that other projects have been developed in the city in the past 5 years based upon a zoning determination exactly like the one that we marked as A15. So, and this board has approved those projects based upon zoning determinations, and those projects have been built. So this is not a case of first impression for this board. I'm asking you to honor the precedent and honor the municipal land use law rules and regulations and the process that we followed to get to this point.
Mr. McCann, I suspect you want to mark the 303 First Street resolution A16.
I do, sir.
So marked.
I would have one last thing to say. If the redevelopment plan has expired, there's no zoning applicable to this property. I don't think that's been considered by my adversary. But there is no underlying zoning here. If there's no zoning is a legislative creature. So the MLUL gives a municipality the authority to adopt zoning ordinances. But municipalities don't have to have zoning ordinances. And if they don't have zoning ordinances, then property owners can develop their property any way that they want without regulation. So when the Board of Adjustment made their decision in 2021, that's now A16, that was another factor that they considered. Redevelopment plan expired, no zoning. I would argue you still have to give me a site plan approval if I comply with the procedural requirements of the municipal land use law by proposing a site plan application, there's no zoning to compare it to. So I'm still entitled to develop, my client's still entitled to develop their property. So for all those reasons, I'm asking you to honor the zoning determination that was issued for this project.
You want paper copies of? If you want paper copies of the resolution for 303 First Street, we can definitely make that available to you, Mr. Chairman. I do believe so.
It's not available on the portal, correct? Council, that wasn't submitted to the portal, correct?
So I
It's not.
think,
So
Mr. McCann, I don't. The internet's slow in the room, Mr. McCann. That's why the pause. I'm waiting for the tablet to load. I see you looking at me as though I want to say something. I do want to say a lot of things, but that's why there was nothing wrong with paper. Of course, it's the last thing on the portal.
So
Hold on, Mr. McCain.
I'm just going to say I do have a hard copy with me. If you want to take the time to have somebody make copies, we could do that.
So, Council, the reason I asked for it is I just asked Mr. Cavalar's, or I asked that of Mr. Cavalar a few moments ago, because I don't think I should take anyone's word on the highlights that they want to give us. No offense. I'm sure
No
you're-
offense taken.
I'm sure you know we don't.
I'm familiar with what you're saying.
It's all business. So, I'd like to thumb through that determination, that record.
Cam, is it on the portal? Do you know? I happen to have a copy of it. I also happen to have a copy of Mr. McCann's letter submitted October 2nd, 2024. Request for a zoning determination, and that letter,
The zoning determination letter is on the portal.
okay, Exhibit A to that letter, I believe, is the resolution for 303 First Street. So, Mr. Chair, while we try to ascertain that for you so that you can read it, do you need to hear from Mr. Caliber? Do you want to give Mr. Caliber the opportunity to respond to Mr. McCann's argument? I'm sure he would welcome the opportunity.
I would like to give that opportunity first to Ms. Hagianis, if you have anything to add. If we could, let's get you up on mic with your answer, just so the internet can hear you tomorrow.
So she shouldn't get a chance.
She should get a chance.
Okay. Well, I'm sorry, I always have trouble with this microphone, but just and apologies, Cam, in advance. Just rather briefly, and I also did not receive a copy of the letter that Mr. Cavalar submitted, and I believe it was not uploaded to the portal, but I've listened to the arguments, and I just would say that the Caven Point redevelopment plan is a legislative act. I don't believe that the zoning officer has authority, and I was just looking at the MLUL to see what the powers of the zoning officer are, but I don't believe a zoning officer, they may be able to interpret the legislative acts. I don't know that they can contravene them. So I believe, and maybe this will ultimately be determined by a court, but I don't know that reliance on the zoning determination is going to be an airtight legal argument. Thanks.
Just to point out that it's the Board of Adjustment decision that was the basis for the.
Yeah. Again, though,
zoning determination.
I don't think they can contravene an ordinance. That the redevelopment plan is essentially a mini zoning ordinance, and I don't know that the zoning officer can alter that redevelopment plan that was a legislative act of the council.
All right, thank you, counsel.
Chairman, you can ask me any question you want. I have an opinion, obviously, but
Sure.
do you want to give Mr. Cabellar a chance to retort
Absolutely.
Mr. McCann's position? I think that would be fair and appropriate, and then whatever questions the board is struggling with, I'm going to be happy to help them.
I'll be very brief. I know we have a lot of talk about this letter from the Division of Planning. The rebuttal to that is the fact that it was done prior incorrectly doesn't mean we should continue to perpetrate that. Doesn't mean the planning board is bound by that. The point about, the MUL says that the planning board cannot put in place a moratorium. Planning board's not putting in place the moratorium. The city council put in place that moratorium. The city council has that legislative authority. That is the law of the land. And then in terms of the comment that once a determination is issued by the city of Jersey City, you're bound by that. If that prior determination from 303 First Street, you're bound by that. You're only bound by that if that determination complies with the law. At the end of the day, this does not comply with the law. I've stated all the reasons why, and if you determine, or if it's determined that it doesn't comply with the law, then at the end of the day, there's no time frame in which to appeal anything. If something doesn't comply with the law, this plan expired, there's no time frame to appeal a planning zoning division letter in terms of the application or interpretation of the law by the Zoning Board of Adjustment. Something either does or does not comply with the law. And if the ordinance expired, it could be raised at any time. And we raised it at the start of our case, and we said we would raise it in our objector's case. We've done that. We knew we were placing our objector's case on the record. We've done that. And we asked the planning board to make a decision in that regard before continuing further.
So, Mr. Cabellar, based on your position, is it safe to assume that you did not take any action regarding this issue in front of the zoning board?
We did not take any action regarding this issue in front of the zoning board, correct?
And you have not filed an action in the Superior Court regarding this?
We have not filed an action in the Superior Court regarding this.
Okay.
This will certainly preserve the record, obviously, in that regard.
But as we sit here today, those two things have not taken place.
No, they have not taken place.
And in response to Mr. McCann's position that if it's determined that the plan has expired, what is your position with respect to what the zoning is for this property?
Sure. I haven't gone back and looked at that. I will do that and see what the zoning was prior. I'm not familiar with what Jersey City zoning was 40 years ago. I do know this redevelopment plan has expired. So if there was some zoning applicable to it, perhaps it reverts back. I haven't gotten that far. I haven't researched that. But I'm happy to address it, and we'll address it in our opposition.
So the Board of Adjustment decision points out that Jersey City's 1970, I don't remember exactly, I know you'll check me, thank you, zoning ordinance was repealed and replaced by the 2001 zoning ordinance. So any zoning that applied to this property at that time in 1977 is gone. No other zoning was adopted for this property other than the Caven Point redevelopment plan. That's another reason the Board of Adjustment came to the decision it did. There is no other zoning. That's why it's the permanent zoning. When the City Council adopted the zoning map, they made the Caven Point redevelopment plan zoning regulations permanent. I
Thank
have
you, Mr.
researched
McCann.
that issue. Which, if I could suggest politely as ever could be said, this is not an issue that this board should decide tonight like this. The board should rely on the zoning determination that was submitted as part of the application. The application was deemed complete, and we've already started a hearing. I understand Mr. Caballar's objections, but the zoning board of adjustment is the place where this issue was decided, rightly or wrongly, and if Mr. Caballar has a problem, he can appeal that to the Superior Court after this case receives, or doesn't receive, I don't know what the answer would be, a site plan approval. And I'm making that really, I can't be any more polite, but it's my suggestion.
You could have said please.
I would just quickly respond to that point, that whether it's now or at the conclusion of the case, you have a decision to make. And if your decision is, I'm denying this application because I believe this plan is expired, that's your decision, and that's your right to make that decision. You can pick any reason, whether it's the reasons that will be raised by my expert or a reason that we've raised here tonight in terms of the expiration, to deny the plan.
If Mr.
That's your
Caballar,
right.
sorry. If Mr. Caballar is right, what is the point of zoning determinations at all, and what is the point of bringing cases to the Board of Adjustment when the land development ordinance says that's what you're supposed to do? It can't be a situation where any board can ignore the decision of any other board.
Or the city council.
Precedent
All right.
counts.
Gentlemen, I've given you way too much leadway in arguing back and forth, so.
So, counsel,
Counsel me?
Sure.
Okay.
Do we know what the underlying zoning was before this redevelopment plan was adopted?
Who are you asking the question to?
That would
Me?
be you, yes. Or planning staff.
Okay.
Do we know what the zoning was?
So, go ahead, Sophia. It should be,
I'm not aware of what the zoning plan was before. I do know, and I have the map up here on my screen. This is the redevelopment plan that is on our zoning map, and this is what we would refer to.
so Chairman, I would say that I don't know its relevancy for dealing with the actual question and position of the parties. So we have to deal with
You're right.
the objection being the redevelopment plan says it's expired. It's been more than 40 years. The
Counsel,
weird twist of faith.
counsel, I'm really sorry about this, but before you do this, we have another argument that was going to be part of my proofs. But we filed our application before the redevelopment plan expired. I don't concede that it expired, first of all, but our application was filed on September 18th, 2024.
What's the expression? You can't put the toothpaste back in the tube? Why wouldn't you have led with that and dealt with that issue?
Well, because belt and suspenders, okay?
Okay. So then we're going to talk about it all.
Let's talk about it all. So
And by the way,
why don't
I
I
was aware with that, but I'm making you do your job.
why don't I bring up Mr. Lean, who is going to,
Why?
well, because he's going to ask the questions to our witness to confirm for you that we filed our application, a substantially complete application, on September 18th, 2024, which is almost 2 months before this redevelopment plan allegedly expired.
Let's see if we can do it a little faster.
I'll acknowledge it. You got it. Done.
How's that? Council stipulates to that fact. Now, that's a gentleman, Mr. McKenna. Stipulates to the fact that your application was filed prior to the calculating of the 40-day,
40 year.
40-year date.
40 days would be nice, but it's
That would be unrealistic.
So
I know, it's shocking.
it is shocking.
I can explain why if you'd like.
Do you want to know?
Well,
Do you want to know?
We must.
the time of application rule,
You want to know why he stipulated?
sure. Sure, yes, I want to know why. Go ahead.
The time of application rule applies to changes in the law. There was no change in the law. The plan expired when it expired. His application had to be completed by that time. He knew the law when he filed. The law is the law. There was no change in the law. So there's nothing to consider in terms of the time of the application. If, for example, he filed his application in September and Jersey City Council decided to further amend the redevelopment plan, he would not be bound by those amendments because time of the application goes under what it was. At the time that he filed, the law was it expires in November. It expired.
You guys
time
can
of
ask all the
application.
questions you want. Let's get them out. I have opinions. I don't want you to think I don't.
Okay, I guess my question is partially for planning staff and partially for the board council. We hear a lot about this expiring at 40 years, but then we also heard that it was sort of enshrined in this 2021 map, and so this map was voted on by the council at that time.
Correct.
And would the vote on that map, and the zoning on that map is identical to the zoning in this redevelopment plan that we're
Correct.
arguing whether or not it has, it has allegedly expired, but then is that expiration valid? But so the map, would the map then, even if it has expired, right?
Right.
Would the zoning on that map continue to be in effect? Would the map supersede the expiration, I guess is what I'm trying to ask.
Great question. So the MLUL has various provisions and various sections. So what Mr. McCann is advocating is under the section of the statute, it's section 70. There's 3 subsections, 70A, 70B, 70C, 70D. Then you get into section 72, A and a B. And in those sections, when you hear I need a C variance, that's under 70A. When you hear I need a D1 use variance, that's under 70D. The D variance is under section 70. There's 6 of them. Exclusive jurisdiction before the Zoning Board of Adjustment. We will never hear those at this board. This board does not have the statutory authority to hear those. The C variances, sometimes called these bulk variances, side yard, front yard, things of that nature. They get heard here all the time in conjunction with various site plan applications. None of that is really what this is about. This is about, okay, the zoning officer made a determination. The zoning officer has that authority, exclusive to make that determination under the MLUL. When that determination happens, if you are aggrieved by it, whether it's in favor of somebody else or against you, you can appeal that decision. You can only appeal that decision to the zoning board. The map can only be interpreted by the zoning board. This board can't interpret the map. So usually the situation with the map that becomes problematic is, where is the zone line? Is this a split property? Is the zone line in the middle of the street? That's generally the most common situation of map interpretation. But it's all at the zoning board. It's not here because the statute doesn't allow it to be here. The map, like the legislation, is absolutely controlling. And if the map says something, it's been ratified by the council vote adopting the map. Then it goes online, it's there, it's dated, it's stamped, and it lays out all of the different zones and what controls those zones. So yes, the map is absolutely an authority for this board and the zoning board. But if there's a question about that map, this board can't decide that. This board has to allow the zoning board to make that determination. And the zoning board can only make that determination if somebody brings it to the zoning board. So if the zoning officer makes a determination and says, this property or this parcel is in this zone based on my review of the map, and nobody does anything about it, then that moves forward with that determination. The zoning board can't say, we don't agree with what the zoning officer did. We're going to somehow pull this from them and hear it and decide it on our own. It's got to be brought to them for them to have that jurisdiction. So I think that may have gone a little further than the question.
This is my first planning board meeting, so I appreciate the in-depth explanation.
Happy to do it.
Thanks.
I'm sorry, counsel, just to, I guess, clarify, and you can confirm, the question before that's being raised today is, does this expiration date apply for zoning purposes, which is also not the sole purpose of a redevelopment plan or redevelopment designation, correct?
So that is part of the package.
Yes, okay.
But that issue, right, is not, the question is,
It's not
what is
germane
the zoning of?
and it's not
right?
germane to the board's decision on whether or not to approve a site plan or to hear a site plan. Correct?
I would agree with that.
All right, thank you.
Counselor, question. I understand that someone who receives a zoning letter could appeal it to the zoning board, but would an objector or a member of the public have standing to do the same?
They would. They're an interested party. They can bring that objection. The real question becomes, are they bound by that 20-day time limit to file that appeal to the zoning board? And I think the courts give them the concept of, when did you get notice in order to file that appeal? But we just had this issue raised in another case where a determination was made, and the way the application was brought forward was, it was an appeal of the decision and a variance case to expand something. And that application was brought forward at the same time. If you deny this and continue to agree with the zoning officer, then we're opposing the application that they're also bringing based on that determination. Not this board, not here, but. And there are cases that deal with this. There's a case out of Colts Neck that deals with this, and there's the DiPietro case out of Wayne that deals with some of these issues. And, you know, if you want me to go further on that, I'm happy to at this point. But yes, it's anybody that gets or is aggrieved by that decision. So that's why I had asked Mr. Calber if he moved in those two forums.
Santo, can you go into the time of application rule on this? What's the precedent there? Is there one?
The time of application rule doesn't change. It's the date that you file your application. Whatever law is in effect at that time is the law that governs your application. It used to be the time of decision rule. And we've gone through this, you and I, probably 3 or 4 times a year over the years.
Yeah.
So they changed the law. It used to be the time of decision, but obviously what the legislature determined was applications are being filed, people are reacting to that and changing the law, so we're going to make it the time when the application is filed. And the most recent case that this board has been involved in that interpretation was the Canvas Place Corp case with Cushmart, and the court and the appellate division determined that this board was absolutely right.
And still one of my favorite dispensary names across the city. But
The statute itself is on the screen at this point,
Thank you.
just so you know.
thank you, counsel. So to Mr. Caballar's point, does the time of application, is that affected whatsoever because of no new legislation being added, changed, revised in the redevelopment plan in question?
Well, so the redevelopment plan has been amended over the course of its life.
Sure.
So the redevelopment plan was adopted, obviously, as we sit here today, more than 40 years ago. There have been a bunch of amendments, the most recent one being, I believe, in 2022. But I may be incorrect about that. So is it a ratification of the redevelopment plan every time an amendment is made to the redevelopment plan and the redevelopment plan is subsequently adopted? How does the redevelopment plan interact with the concept of the master plan here in the city? These are all really good questions. I think the answer is every time an action is taken in furtherance of something, there's a recognition that that is valid. You don't go and amend something that's invalid. But, does that mean that if you amended it and 3 years later it expires, that it doesn't expire? I don't think that I would go that far, Chair. I think if you amend it and it still has that sunset, I think that sunset is still there. The question is, what happens when it sunsets, and is the sunsetting of it valid, or is the zoning component of the plan still valid? Does it exist until the zoning component is changed? Or do you have a situation where, okay, the underlying zoning in the Cabin Point in the 70s was, what could it have been? It was a landfill. We going back to landfills? Didn't they build the land in the 70s? I'm not that old. Mr. McCann, I don't know if you were around in the 70s, but I thought they created the land.
So, can I have another turn?
Sure, counsel.
So, the statute that's up there is crystal clear. That's the time of application statute. It says that the law that any board, the Board of Adjustment, the Planning Board, should apply to an application is the law that was in effect at the time the application was filed. It doesn't matter if the redevelopment plan expired. it doesn't matter if the city council adopted an amendment 2 weeks after this was filed that said we're voiding the Caven Point redevelopment plan. The whole point of the statute was put in place to protect applicants who rely on a zoning regulation and invest hundreds of thousands of dollars in preparing plans to comply with those zoning regulations, and then having a legislative body, either through action or inaction, pulling the rug out from under them. That's what the statute was adopted for. It was adopted in 2010, I think. That's not that long ago.
So, Counsel, I don't disagree with what you're saying, and I think to your point, yeah, the exact thing that happens or was happening that the law got changed to prevent was applications were filed. They were pending before the board, and governing bodies were changing the law on pending applications, and that's what was changed. But I understood the question to be, does the amendment restart the 40-year provision of the plan?
I would concede that the previous amendments through whatever it is, 2022, did not extend the 40-year period. I would concede that.
But I think that was the question.
Okay, well, we have that one answered, because I don't think it did either, to be perfectly honest with everybody in this room.
This is crazy. So me and Mr. Cabellar agree, and me and Mr. McCann agree in one night. It's time to go home.
Baffling.
But it doesn't matter. The time of application rule is fabulously clear, and it's there to protect applicants exactly like my client, who spent a lot of money to comply with a redevelopment plan and filed the application before it allegedly expired. I don't concede for 1 minute that it expired. I made that argument. The other thing is, whatever the zoning was in 1977 is completely irrelevant at this point, because the city council repealed the old zoning ordinances and put the 2001 zoning ordinance in place with the Caven Point redevelopment plan as the zoning. There is no other zoning. None. Zero. Those kids over there can research the crap out of this. They're not going to find any other zoning that they can say is in effect to replace the Caven Point redevelopment plan. I know that.
Counsel, I'm looking at your application, your general development application. I don't see a date. Can you provide me something? I see Mr. Lean jumping into action.
Yeah. Yes.
Mr. Kalber's already stipulated to it. You can't unstipulate.
I'd like to say it.
Okay.
I'd
For the
still
record.
like to see, yeah, for the record, I'd like to say it.
So what I can offer to council, very simply, is a screenshot of all the documents that were filed as part of our application, along with our cover letter.
What's the date?
The date of the cover letter is September 18th, 2024. Now, once this letter gets filed on the portal with the planning division, the staff uploads all the documents that were filed. And they have dates on them. So what I can give to council is a snapshot of all the documents that were filed under this cover letter and show you that all the dates are well before the alleged expiration date of the redevelopment plan. They're all in September.
We're going to mark it as A17 and A18. A17 will be give me the date of the cover letter.
September 18th, 2024.
September 18th, 2024 cover letter.
And we'll put into evidence, if you want, every single document that's under this cover letter. Mr. Lean is prepared to do that. You didn't ask for that yet, but if you do, we'll do it.
Why does Mr. Lean have to do it?
Because I need a break. I'm old.
A18 was what? The screenshot of the documents?
Yeah. Do you want to mark these? You want me to mark them? Why don't I hand them to you so you can look at them and pass them around?
I'm going to mark them. I was hoping you had a copy for Mr. Caliber, because he's going to want one next.
I'm good. I'm not a fan of paper.
Sorry, you need to add one more exhibit. There's another screenshot.
A19.
Sorry, some of our junk was on.
Council.
Commissioner?
Just one other question for you. I'm just reading the language as was provided from the redevelopment plan about the expiration. I was wondering if you could just clarify, as I read it, or I'll read it. The provision of this plan specifying the redevelopment of the project area and the requirements and restrictions with respect thereto shall be in effect for a period of 40 years from the date of approval from this plan by the City Council of the Jersey City. Can you clarify for me, as I read that, it says it's affirming that in the first 40 years after the passage, these will be in effect, but I'm trying to understand how to interpret that beyond the 40 years, and if it's clear that they're no longer in effect beyond the 40 years.
So I think that's exactly what we've been discussing and council has been arguing about. I think the question has to be narrowed. You can't take the entire plan, look at this provision, and try to figure this out without understanding what the zoning board determined after the position of the zoning officer was given the first go-around. So the first go-around was, here's our zoning determination. It is, these plans expired, there's no zoning in place. Mr. McCann has a client who becomes the unlucky recipient of that determination. Mr. McCann says, okay, I am sure he screamed at the zoning official in the nicest of ways possible, trying to convince the zoning official that he was wrong. When the zoning official would not back off of the decision, Mr. McCann appealed him, said, you're wrong, I know what I'm talking about, I'm going to the zoning board. He gets to the zoning board and he gets his vindication. The zoning board says, McCann, you're right. And now the zoning officer says, okay, I don't necessarily agree or disagree, but I have to continue to follow that. I'm bound by that. And the cases, the statute is clear, the cases are clear. Once the zoning board issues their determination, the zoning officer is bound, this board is bound. The only place to go from there is into the court. The zoning board may be wrong. The zoning officer may be wrong. But this board doesn't have the authority under the statute to do anything about that. This board has to accept whatever determination the zoning board makes, or the zoning officer. If Mr. McCann, in this situation, got a favorable decision from the zoning officer, he's not going to appeal that to the zoning board, which is why I asked counsel for the objectors if they had appealed it, because if that was pending at the zoning board, And the zoning board was maybe going to revisit this and change its position and give reasons why it felt that way. Maybe we would have something to say, well, let's see what the zoning board does. We don't want to rush into this. But the law is the law is the law is the law. So until the judge tells the zoning officer and the zoning board they were wrong and here's the reasons why, that's where we are. But I don't know that you have to get there, because you have the time of application issue. I think it's best practice to deal with both of them. How do we feel about the time of application? How do we feel about the determination of the zoning officer? I would advise the board that these are legal determinations and they get reviewed by the court without, they're a de novo review. It's a matter of law. You either were right or you were wrong, but the court doesn't really give nearly as much weight to your legal mind as you give to your legal mind.
It's very little to begin with.
So, Santo, I have one last question on the time of application rule. I do see Mr. McCann's submission to the Planning Department, the cover letter dated September 18th, 2024. How is the application date determined? Is it by cover letter? Is it by?
When you submit a complete application. So if Mr. McCann's application was complete upon submission and it followed the checklist, that is the date.
So I would go to staff. Can we determine if the application was complete when received?
You speak to each case separately, or?
I would say that depends on what's considered complete. So
What was missing from the checklist, I guess, is the best question.
Sure.
And if it was fees,
So if we're going to go down this road, I want to put all the documents and have them all marked as exhibits. I'm not sure what's, before Sophie says anything, plus Mr. Cavalier stipulated, so, I don't want to put Sophie in a bad position.
I don't disagree.
Yeah.
And Mr. Cabular stipulated. So
Okay.
the operative date is
September 18th. Correct.
September 18th, and the redevelopment plan was first approved on November 7th, 1984.
Okay.
So allegedly it expired, I thought November 6th, 2004, 24.
I stood up
Allegedly.
before to make this point, and I just want to make sure, because I think Mr. Lampe understands my argument. Whether you agree with it or not, fine, but I just want to make sure the commissioners understand my argument, because what is on the screen says the law in effect at that time, right? So the law in effect at the time of the application was that it was going to expire in November. It doesn't extend that expiration date. What that law means is the law in effect at the time that you apply is the law you must apply. Right? That's the law you must apply, that it expired. It means the zoning can't be changed on them at the last minute. That's the rug being pulled out from under them. They knew the expiration date at the time they filed. That was the law in effect at the time they filed. That's our argument. I understand council's argument is different than that. I just want to make sure for the record, the board understands our argument, and if you have any questions, obviously happy to answer those.
Mr. Cavalier, can you point to anything that I'm looking at right now that supports that?
Yeah, the regulation says it. They're subject to the law in effect on the date of submission of an application. The law in effect on the date of the submission of their application was that redevelopment plan expires 40 years from its original adoption, meaning in November it expired. They're subject to the law in effect at the time of their application. And that's why I wanted to get up here and re-explain that, because it is easy to look at that and think under the normal circumstance, time of application, all we look at is what was in effect at the time, because normally the time of application rule is designed to prevent a change in the law. For example, if Jersey City decided to get rid of the redevelopment plan after the application was filed, they wouldn't be subject to that. But the law in effect at the time they filed was this expires in November.
Does that go back to the other point, though, that eventual, that shouldn't disrupt any developments in process? I think that there was another point that was up on earlier, essentially saying that it can't disrupt any development.
I think, Commissioner Wick, you're talking about the moratorium section.
Yes, thank you.
Right.
Does
Yes.
that override that? I don't, you know what I'm,
Yes,
Okay.
I understand what everybody is saying.
okay.
This is, this is Tuesday night.
Speaking of Tuesday, no, just to follow the opposition counsel's argument through for a moment, in this scenario where an application was submitted immediately following the expected sunset of a redevelopment plan, would that preclude, say, city council from extending the redevelopment plan, and the applicant would then be able to allow it to, file it knowing that it would sunset to lock in its conclusion, if that's to their benefit?
Would the city council,
Or whoever would extend the date.
I didn't follow the question.
Sure.
I'm sorry.
By filing an application immediately prior to the conclusion of the redevelopment plan,
Got it.
does that prevent the redevelopment plan from then being extended? Or to therefore
Prevent
continue?
the council from taking the action of
As it
extending
as
the
it relates to that
redevelopment plan?
application?
I would say no. So there is a case, Sam Rami, that stood for the proposition that when the ordinance changes in the favor of the developer, you no longer need the variance, right? Which everyone's like, how could that be? You filed it before, time of application rule. But when you think about it, it makes actual sense. The governing body decided that what we said wasn't permitted in a zone, we've now made permitted in a zone. Why would you get a variance for that? We've changed it to make it permitted. So if the governing body were to extend this redevelopment plan or remove expiration dates from all redevelopment plans, it would be very helpful. But no action doesn't stop things from happening, right? Or inaction. My kids are struggling with that concept.
Santo, if I may, based upon the opposition attorney and his interpretation of it, is it possible to say that his interpretation is at the time of application and the sunset of the law, the project should have been somewhere started, completed within that period of time since it expired within that 40-year period of time?
I don't think he gets to that point, right? I think his argument is The law at the time expired 2 months after they filed their application. They knew that. It happened. And the law didn't change. It expired. That's his argument.
Which is actually no different than when an applicant knows that the planning board is going to recommend a zoning change in a particular area and refer it to the city council, and the applicant files their site plan application before the legislation is adopted by the city council. The time of
the
application
legislation's already
application
adopted.
rule
1 second,
applies.
Counsel. I want to hear you, but I don't.
The time of application rule applies. It's like he's trying to say, because we were on notice of the expiration of the redevelopment plan, that it's still expired. That's not what that says right up there on that's not what the statute said. You can be on notice of a zoning change. You could be on notice of a zoning expiration. But if you get your application filed while the law is still in effect, that's the law that applies. That's the end of the story.
Counsel?
He said a key word there. If they know it's going to be adopted. This already was adopted. The law in effect at the time. This is not the situation, and that's why I keep making that distinction where there's going to be a change in the law and you rush in to get your application. The law already exists. It's there. This is a different scenario entirely.
So, Chairman, I'd respectfully say this. If you allow me, Mr. McCann, and Mr. Cavallaro to argue, we will do this
all night.
I
All
know
night.
that about the three of you.
Okay. So it's time to make some decisions.
Yes.
We've got a lot of positions put forth. How can I help the board?
Chairman, I just want to make sure we have a second opposition to council. I don't know if you wish to give them an opportunity before we conclude.
I would like to give Ms. Hagianis the final word here before we make any kind of decision.
Thank you. I appreciate that. And I don't know that I have anything really definitive to say, but I did want to just point out, I think there had been a question about the underlying zoning. And the first paragraph of the Caven Point redevelopment plan does say that it serves as an amendment to and a substitute for the Liberty Harbor redevelopment plan, and it affects the Caven Point area. And that plan was adopted in 1973, according to the Caven Point redevelopment plan. Now, this becomes complicated because I know that plan has undergone many amendments since 1973, but I think if the Caven Point plan is expired, what you might be left with is a prior iteration of the Liberty Harbor redevelopment plan. Thank you.
Okay, thank you, Ms. Hagianis. Do you have a question?
Yes,
for Santa?
Santo, I have a question here. I hear about zoning officer signing a letter, but the only letter that I saw here that came out of Division of Zoning is signed by a planner, assistant planner. Am I missing something?
To my knowledge, Eric Beasley was the zoning officer at that time, and yes, he is a planner.
So, Mr. Beasley, in his capacity as a staff member in both planning and zoning, authored that letter on behalf of the zoning officer, which the zoning officer approved, which is routine practice that staff, Mr. Beasley was under the supervision of the zoning officer.
Okay.
And the zoning officer was Tanya.
Miss Tanya Marion, yes.
Okay, understood. Okay with that?
That's what it is, that's the point.
So, does the board have any other questions for our counsel before we make a determination here? Okay.
I guess the map that the council voted on did not have an expiration date, correct?
Correct.
Correct.
And by the way, it has all, I think there's like 58 redevelopment plans on that map. And as Mr. McCann indicated, there's a good amount of them that are
Yeah.
allegedly expired.
Yeah. So I'll start and then I'll open it up for everybody. I believe this is rightfully in front of us right now. Based on time of application rule. And that alone, I don't think I need to go further into the weeds on Mr. McCann's original argument. That being said, that's my interpretation, council. That's your interpretation. But, you know, this is the Jersey City Planning Board, not Chairman Langston's Planning Board. So if anybody else wants to chime in, disagreement, agreement,
Chair,
open book here.
Chairman, in concurrence, it seems like the appropriate jurisdiction for the questions raised is the zoning board, not here. So even if we were to opine and make a decision, it doesn't seem like it would
Agreed.
matter. So I think for those reasons, I'm in concurrence with you.
Absolutely.
Yeah.
I agree.
Agreed, and if we're wrong on that determination, let a higher authority tell us that.
Correct.
So,
So the board has spoken. I think we need to give Mike a break.
Mike?
So that, just to be clear, before the break, you're determining that based upon the time of application rule, this application goes forward.
And if we're not correct on the time of application rule, the jurisdiction to hear the issue on the expiration is with the Board of Adjustment.
Okay, thank you.
Okay.
All right, I could use a break too, so I'm with
I
Michael.
think everybody needs that right now. So, yeah, let's take a break, everybody. Mr. McCann, I believe the floor is yours.
Okay, thank you. So I think the place that we're at is I'm going to introduce my first witness. I don't remember if I introduced him yet, but he's our traffic expert tonight. His name is Mr. Carl Penke from Langen Engineering. He's going to provide some supplemental testimony in addition to what the traffic expert testified to in September.
I do. The record, just put the mic on. Again, my name is Carl with a K, Penke, P as in Peter, E-H-N-K-E.
Mr. Penke, always a pleasure to see you. Your license is current tonight?
My license is current, thank you.
Okay, thank you. You're qualified.
Thank you.
So, Mr. Penke, I'm just going to ask you a couple of quick questions. Can you confirm for me that you reviewed the transcript from the September 9th hearing before this board?
I did.
Okay. And at that time, your colleague, Kerry Penke, testified regarding a traffic study that was marked in as Exhibit A14. For the record, I'm going to show you a copy of that and ask you if could you just open that up and confirm that's the study that was introduced at the last hearing?
That is correct,
In
dated September 6th of 2024.
Okay, thank you. And then I'm going to show you one more thing. This is a letter from the Jersey City Department of Infrastructure dated October 8th, 2025. Have you seen that letter before?
I have.
Okay. Council mark that as A20. Okay, and at the September, thank you. At the September hearing, there was traffic testimony, and the board raised the question of whether the traffic counts could be relied on by this board because they were taken when school was out. A number of board members raised that issue. And then a few days later, the applicant received A20, which is the letter from the Department of Infrastructure, and they raised the same issue regarding the parking counts. So the applicant, so now I'll turn over the presentation to Mr. Penke. Mr. Penke, what did the applicant do in order to update the traffic counts for the project?
Mr. McCann, just give us the date of that memo again.
October 8th, 2025.
Good. Okay. So certainly, as you heard at the testimony in September, Kerry reviewed the traffic impact study that was submitted and offered testimony that the results of the traffic study confirm that the driveway for the project will operate at good levels of service and safely, and that the key critical intersection of Chapel Avenue and Craven Point Road would be modestly impacted, but really would not change in terms of level of service operations. But as was just discussed, there was some question raised as to whether August data is representative of data at other times of the year, particularly when schools are in play. And I would offer two things in response to that. One, in terms of evening peak hour traffic, that's really not influenced by school traffic, so the August data would be representative. In fact, I would argue that it probably is generally higher because of other activities that we all are involved with in the warmer months, particularly in this portion of the Jersey City. But also then to validate our conclusions, we did take the opportunity to conduct additional traffic counts, which we did in October of 2025, October 7th specifically. We verified that school would be in progress. We went out and recollected the data and did an updated supplemental analysis to recheck the intersection. The response or that information was documented in a supplemental traffic statement dated October 17th of 2025.
Is that a copy of your?
That is a copy of the memo that was prepared. To put it straightforward, if you had a chance to review that, in this particular case, the October data actually came out to be either dead on or lower than the August data. In fact, if you looked at the data, the intersection during the AM peak hour back in August when we originally counted it in 2024, there was approximately 1,300 vehicles traveling through that intersection during that peak 1 hour period in the morning. When we went back out in October, we basically found 1,300 vehicles traveling through that intersection, almost exactly the same volumes, almost exactly the same traffic patterns occurring through the intersection. So that was a verifiable count of our prior data. Similarly, in the PM hour, the traffic patterns were observed to be relatively the same in October, except that they were probably overall through the intersection a little more than 100 vehicles per hour less. We then took the next step. We took that data, replugged it into our models, and rechecked the analysis. We also took the opportunity to observe the traffic signal operation and timing just to make sure that we were running the analysis with what we were observing in the field. And basically, we reconfirmed that the intersection generally operates at good levels of service and will continue to do so when this project is completed. And that's all documented in that supplemental memo. So the September 6th traffic data is verified by the latest traffic study. And that's I think, the update that we have to offer.
Thank you. And just to add, the supplemental traffic study, which is dated October 17th, 2025, and is being marked as A21, has been posted on the planning portal since October of 2025.
Okay, thank you, Council. Any questions for Mr. Penke? Anyone? Council, any cross? Ms. Hagianis, any cross? Okay,
Thank you, Mr. Chairman.
thank you.
Thank you.
Board has no question.
Board has no questions.
Next witness is my civil engineer for the project.
I do. My name is Brian, B-R-Y-A-N, Waisner, W-A-I-S-N-O-R.
Mr. Waisner, good evening. Your license is current tonight as well?
It is.
Okay, thank you. You're qualified.
Thank you.
Did you swear? Mr. Waisner, you testified before this board on September 9th, 2025, correct?
Correct.
And have you reviewed the transcript from the September 9th hearing to prepare for tonight's hearing?
I have.
And at the time of that hearing, the civil site plans that you testified regarding was a series of civil plans with 37 sheets starting at CS 001 and ending at CS 503, last revised October 26th, 2025, correct?
That's correct.
And you've reviewed the record from that hearing, and those plans were marked A3 for identification, is that correct?
Correct.
Okay. And at the time, we advised the board on the record that those plans addressed some of the comments that we had received from the Division of Infrastructure, is that correct?
Correct.
And we also advised them that we addressed some of the comments that we had received from the Jersey City Municipal Utilities Authority, but not all of them, correct?
Correct.
And we also advised them that we had addressed some of the comments from the HOA's experts that had submitted comment letters, but we had not had the chance to consider them all. Is that correct?
That's correct.
Okay. So when we came to, so you were also in attendance at the October 28th, 2025 Planning Board hearing, is that correct?
Correct.
Okay. And between that date and the September 9th date when we presented our set of plans that are A3, we made more revisions to those plans to address the comments of the persons and entities that I just referenced, correct?
Correct.
Okay. So what we are offering the board tonight is basically another set of plans that we're going to ask them to approve in lieu of the A3 plans, correct?
Correct.
Okay. And for identification purposes, those plans are civil site plans prepared by Langen Engineering, again consisting of 37 sheets starting at CS001 and ending at CS503, last revised October 16th, 2025?
Correct.
Okay. All right. Council, I have a 8.5 by 11 set of those plans. Mr. Waisner is going to testify, as we usually do, by putting those plans up on the screen. But I can give you a copy of these plans right now. We can mark them A22.
A22, last revised October 16th, 2025, 37-page set, Langen Civil Plans.
And these were uploaded on the portal?
Yes.
Can you,
October of 2025.
can you tell us the file name? I downloaded all the things from the portal and I just want to have them on my screen.
I'm sorry, can I?
Do you know what the file name was? I downloaded everything from the portal.
It's the site plan set, and then in paren revised 10/16/2025. At least that's the title appearing on the document that I downloaded from the portal.
Commissioner, we're going to post them on the screen for you anyway.
Okay.
Okay.
Thank you.
Commissioner, were you able to find them on your downloads? Because,
No. I
okay,
wasn't.
all right, take your time. It's the problem with the portal. It doesn't have a universal setting. It may be civil engineering plans, Liberty Watch, site plan set, revised, 10,
There's a number of
17,
civil plans.
2025.
Yeah.
Okay. Yeah, I see that one. Yes. Thank you.
You're welcome.
Mr. Weisner, in addition to revising the plans, you also updated and submitted a new stormwater management report pertaining to this application, correct?
Correct.
And that stormwater management report is dated revised October 16th, 2025,
That's correct.
identified as stormwater management report for Liberty Watch.
Correct.
Is this a copy of that report?
It is.
Council, going to offer you this report too.
A23. That is on the portal.
Yes.
It is Stormwater Management Report hyphen Liberty Watch hyphen.
Mr. Weisner, can I keep going, Council?
You may.
Mr. Weisner, in conjunction with the stormwater management report and the plans, we also submitted a letter to the board dated October 17th, 2025, which summarized the revisions to the plans and responded to certain comments that were submitted to us by the HOA's engineer. Is that correct?
Correct. Dated 10/17/2025.
I'm sorry, which,
The letter?
the letter is October 17th.
Sorry, 10, yes, sorry.
This is a copy of the letter, correct?
That's a copy of the letter.
Okay.
A24 will be the October 17th, 2025 Langen letter titled Responses to Comments, Liberty Watch, block number 270503, lot number 15, City, Jersey City, Hudson County, New Jersey, Langen project number 101118201. A24.
Mr. Weisner, after we made our presentation at the September hearing, we received comments from the JCMUA in reference to this application, correct?
Correct.
Is this a copy of one of the comment letters that you reviewed?
It is.
And this comment letter is dated October 29th, 2025. It's on JCMUA letterhead, and it's signed by Rajiv Prakash. Sorry,
Correct,
Counsel.
sir.
26?
You didn't finish the question.
That was 25.
25. And in addition to that, we have another letter from the JCMUA dated January 21st, 2026, which addresses certain concerns of the MUA that were set forth in their previous comment letters, correct?
That's correct.
Is this a copy of that letter?
It is.
Okay. And that January 21st letter is also signed by Mr. Rajiv Prakash.
So A25 is the October 29, 2025 JCMUA letter. A26, January 21st, 2026 Jersey City MUA letter.
All right, Mr. Weisner, would you like to now commence summarizing for the board the revisions that we made to the plans in connection with the various letters that I have just referenced?
Sure.
Want me to go through the letters or just go right into the plan?
Just go right to
Let's see if I can share my screen. So this is the set of 37 sheets, the civil plan set. This is the same set that's on the portal. The only difference tonight is I've highlighted in yellow, just for easy reference if we need to refer to anything, the items that have changed since the prior submission. Otherwise, the plans are the same. The comments that we had received from some of the agencies that we hadn't received or gotten to previously included adding some crosswalk paint markings at both Chapel Avenue and interior to the site at the request of the traffic group, Department of Infrastructure. We also added some details for the water and the sewer, specifically at the request of JCMUA as part of their review. And then we also updated the plans or enhanced the design for comments that we had received from the HOA consultants. And really, those comments came down to three general things, which was protecting existing HOA utilities, providing more detail on the grading and the retaining wall that would abut the common property line, and providing additional stormwater analyses. So regarding the existing utilities, I'm going to move to sheet 2 of this 37-page set. It's the overall site removals plan, sheet CD 100. And again, some of the notes that are highlighted here, I won't excuse me 1 second. They include notes to protect or identifying the contractor's requirement to maintain sanitary sewer service throughout construction, to do test pits at the common boundary to cut off any pipes that will not be used on the applicant's property that do connect into the HOA's property. But ultimately, it will be the contractor's means and methods to protect these utilities as they carry out the work. There are also comments in the HOA consultant's letter alluding to utility work that had to be performed on the HOA property. And just to be clear, there is no work, or there is no work proposed on the HOA property. All the work will be done on the applicant's property or on Chapel Avenue in front of the applicant's property. Regarding the detailed grading and retaining wall along the common boundary, I'm going to move over to page 12 of the PDF, which is the grading and drainage, overall grading and drainage plan. And if I zoom in, again, you can see what's highlighted here in yellow on the screen is where there is a proposed wall that follows the boundary of the property or the common property line between the HOA and this proposed application. And this is where we've added more details for spot grades along the wall. We actually, at the request of the HOA, increased the height of the wall in some locations so that the wall was at least 6 inches above the sidewalk elevation on the applicant's property. The applicant's property is going to be higher than the HOA, so the wall is going to be a 6-inch buffer above the applicant's sidewalk, or 6 inches above the inlet, if there is an inlet adjacent to it. And we actually did a detailed grate capacity analysis, which is when you get a heavy rainstorm and the water can't get into the inlet quick enough, it will sit on top of the grate. And if that were to happen, we went 6 inches above that. So we kind of had 3 criteria to determine how high that wall should be, and we met all 3 of those by raising up the elevation there. And although this plan is hard to see, the next couple of plans in the sheet, which I won't delve into in detail, but again, you can see the yellow highlights. And we provided quite a bit of information highlighted here in yellow with specific spot grades, retaining wall heights, low points, and so forth. So we did detail out the plans quite a bit since the original submission at the request of the HOA. And then regarding stormwater, the HOA's consultant suggested at the time.
Mr. Weisner.
Yes, sir.
Before we go into stormwater, can I ask you a couple of questions about the MUA letter dated January 21st, 2026?
Yes.
Can you summarize what the applicant has agreed to in connection with the MUA?
Sure. So this is the January 2026 final letter from the JCMUA.
2021st.
2021st in 2026. So the JCMUA in that letter outlines pump station upgrades that they expect for the project. They're going to upgrade the pump station to accommodate the existing flow that goes to the pump station today from the HOA and from the Oliver. Plus,
Just explain that there is a pump station, just for the new board members, there is a pump station on the property, correct?
That's correct.
And that pump station presently serves the HOA property, correct?
Correct.
And it also serves the Oliver project.
That's correct.
Okay. And that pump station is located on the applicant's property already, correct?
In an easement to the JCMUA.
And it's operated by the JCMUA.
Owned and operated by the JCMUA, correct.
And they, in their comment letters, requested that certain upgrades be made to the pump in earlier comment letters to accommodate this project's sanitary flow, correct?
That's correct.
Okay, go ahead.
So they identified in their January letter upgrades to be made, which will include new pumps, a new alarm and monitoring system, and other related components. The JCMUA will carry out this work on their own pump station through their forces, and the applicant has agreed to reimburse the JCMUA for the cost of the upgrades.
All right. I have a question. You mentioned that the upgrades are to increase the capacity to accommodate the additional sanitary flow from this proposed development. Was the proposed storm flow, the proposed stormwater flow from the increased impermeable surface area also taken into account?
The stormwater is a separate system than the sanitary. It's not a
it's not
combined system.
combined
It's
in
not
this
combined.
part of the city?
It's
Okay.
a storm separate system.
Okay. Most of the city is combined, so.
Yep.
All right,
Understood.
thank you.
Yep. In that letter in January 2026, the JCMUA also addresses a clogging situation that has begun after the Oliver started to lease up their spaces. That has nothing to do with this project. As you know, this project's not built or online. So it's unrelated to this application. Nevertheless, the JCMUA is going to install what they call a netting chamber that will catch some of the debris before it clogs up the pumps. They're going to do that. JCMUA is going to do that on their easement using their forces, and the applicant has agreed to pay 1/3 of the cost of that netting chamber.
Which is all that the JCMUA asked us to pay, correct?
And is that proportional because the netting chamber is expected to be handling rags from other sources as well, and they're expecting that this proposed development would contribute about 1/3 of the rags to be caught in these screens.
So the answer to that is yes, because the HOA will use the netting chamber. They will benefit from it. Because I think honestly what we were told by the JCMUA is that when there's a backup, which I think they believe it's being caused by the Oliver, it actually negatively affects the HOA's property. So our client, the applicant, agreed to pay 1/3 at the request of the JCMUA, and then the JCMUA is going to, I believe, assess the Oliver owner and the HOA the other 2/3. That's our understanding, at least.
Okay.
That's what's in this letter.
Thank you.
And our understanding is they're carrying out that project independent of this project. They realize that's a immediate need for them to do, and they're doing that, but they wanted us to be aware. And so that's the majority of the letter. They do have some other comments at the end of the letter that confirms that the project's stormwater design meets the city stormwater ordinance. And they note that any remaining items that haven't been caught yet in our plans, they would be fine to allow us to revise them as a condition of approval, but before construction starts, which is pretty typical for a utility type detailing plan.
Mr. Weisner, the pump station upgrades are being made because of this project, but they also benefit the Oliver and the HOA because the pump station itself, a lot of the mechanisms, computers, alarms, monitoring, they're all being upgraded, which will benefit all three of the users, correct?
Correct. Through the discussions with JCMUA, we've learned that the pump station's pretty outdated. It's got non-functioning pieces. The alarm is, several generations older kind of alarms. So they're looking at this as a net benefit to modernize the equipment that otherwise they may not be able to modernize.
So before you get to stormwater, one other thing. On the plans that are up before the board tonight, and council, can you remind me what are they?
A22.
A22. Now, we presented basically almost the same plans in terms of the location of every building on these plans. A22 is in exactly the same place as it was on the plans that were presented to the board in September, right?
Correct. No changes to the buildings.
Right. And the height of every building is exactly the same.
Correct.
And the configuration of where the buildings lie on the property are exactly the same.
Correct.
Number of units are the same.
Correct.
Parking layout is all the same.
All the same.
Okay. So the point I'm making is, and if there's new board members and you have questions regarding actually what the plans have in terms of units and where the units are, we can answer all those questions. But I wasn't going to go through that again because it was already thoroughly presented in September. So can I move on?
Yes.
Thank you.
Chairman, just
Andy,
one
go ahead.
minor
Sure.
question on what
Sure.
you just presented. The 6-inch wall that's going to go around the property, could you just confirm, is there a drop off on the other side, or is this really more like curbing for drainage purposes?
So it's a retaining wall. This application, this property will be higher in some locations than the adjacent property than the HOA. So it'll be a retaining wall. What they're basically asking for is a lip on the top of the retaining wall to make sure that water wouldn't cascade over the wall onto their property.
Would there then be a drop off on the other side of that wall?
It'd be the face of the wall, and there'd be a
Gotcha.
railing and fall protection on
gotcha.
top of the
There
wall.
would be a railing. That's,
Yes,
that's
yes.
real good. Thank you.
No worries. Okay, council, go ahead.
Okay, Mr. Weisner, regarding, so just for the record, we believe that we've addressed substantially all of the HOA's comments, and that's the purpose of this presentation, except for a handful of things that we cannot address, and we're going to explain to you why. So, Brian, I'm going to let you take it away from there if you're ready for that.
Sure. Just again, for some context, where we left off was the HOA consultant had asked us to verify some of the stormwater calculations that we had done, particularly about the area around the site that might be contributing flow through the site. So in response, we had the surveyor verify pipe sizes, connections. We reviewed additional information on the project plans for the Oliver, old HOA old project plans for the site and HOA plans. And we pieced together as comprehensive an understanding as we could, adjusted our model and reran it. And those results are what's in the submission before you tonight, the October 16th, 2025 stormwater report that is Exhibit A23. What's in that stormwater report, which was done specifically at the request of the HOA consultant, is we analyzed the conveyance system. So this is the inlets and the pipes specifically, under the future 25 and the future 100-year rainfall events. This is not required by the DEP, by any regulation or permitting requirement. But under that extreme event, the 100-year rainfall intensity falling on the site with the wet ponds where the water discharges to having already filled up from the future 100-year storm event, it still shows that the pipes, the inlets, the grading of this site will hold the water from this site and not allow it to discharge into the neighboring property. I say it's all above and beyond because the reality is the stormwater for this site is governed by a tidal flood event, and I'll get into that in a minute. So this rainfall-driven event is above and beyond what's required for the design of this site, but we were able to model it, accommodate it, tweak a little grading here and there to provide extra comfort on that. So we understand there are about 3 stormwater-related comments remaining that we haven't addressed.
Mr. Wesner, just one quick thing.
Yes.
We notified the board and submitted as an exhibit a flood hazard permit that we received from the DEP at the previous September hearing, correct?
Correct. We received that permit in March 18th, 2025. And I believe it was marked Exhibit A6.
Thank you.
So the first, and what I perceive as the main comment about the impacts to the HOA property, is what is described as runoff during or the runoff from the 100-year tidal flood event. And I'm struggling to say the words because it kind of mixes 2 different things. Runoff from rainfall events is called fluvial flooding. That's rains, runs off the property, whereas a tidal flood event is when the ocean comes in. It's not affected by rainfall, it's affected by high tide and the winds. So it's really 2 different things, and mixing them together is not how the regulations require you to analyze it, and it's not at all a common occurrence or commonly done in the design of these things. So I'll use an exhibit. I guess I want to introduce a new exhibit.
Yep, please.
We're up to number 27, I believe.
We are up to A27. Is this something that has not been previously submitted or?
A27 is excerpts from the waterfront development permit that I just referenced, which is A6.
So this is an excerpt.
I'm sorry, flood hazard permit, sorry. Apologize.
This are going to be certain portions of A6.
Yes, sir.
So we are going to mark it as A27.
Yes.
We're going
As
to
well
identify it.
as well as some of the Flood Hazard Area Control Act rules.
So there's going to be excerpts of a permit and excerpts of the ordinances that or the rules that they come
Regulation.
from.
But we've combined those into one exhibit.
Yes, sir.
Can we call it a presentation or
The
information?
market is A27. We're going to refer to it as excerpt of, you said it was a tideland permit?
Flood hazard.
Flood hazard, A6.
Flood hazard. March 18th, 2025.
That's the flood hazard permit, yes.
How many sheets of the flood hazard permit?
There are 3 sheets of the flood hazard permit out of 9.
The other 6 sheets are excerpts of the regulation.
Correct. Of 2 different regulations.
Excerpts of,
The Flood Hazard Area Control Act rules.
and
The stormwater management rules.
the total exhibit is 9 sheets.
That's correct.
A27.
Good to go?
Unless
Okay.
we've got A28.
No.
Okay.
Okay, so the first page of this exhibit is the first page of the FHA permit that was issued for this project. So it's the first page of Exhibit A6. And the highlighted governing rule in the upper right corner is NJAC 7:13 flood hazard area, which is the Flood Hazard Area Control Act rule. So this permit refers to this specific rule. Okay, I'll move to page 2, which coincidentally is page 2 of this exhibit and page 2 of the flood hazard permit.
Mr. Wisner, can you zoom in on that?
Sure, please.
Thank you.
And this is highlighted is where the FHA permit identifies, actually NJDEP identifies in the permit that the flood hazard elevation of 12 is what governs this site, which corresponds to the tidal floodplain elevation on the preliminary FEMA map, which is a tidal floodplain map. So this confirms that the regulatory requirement for DEP permitting is the tidal flood, which is storm surge, not a fluvial or rainfall-driven event. Page 3 of this exhibit is coincidentally, for the last time, page 3 of Exhibit A6, the flood hazard permit. And again, to zoom in on the yellow highlight, the FHA permit states that the department has determined that this project meets the requirements of the stormwater management rules at NJAC 7:8. This is referring, 7:8 is the stormwater management rules. This is referring that the state code for stormwater has been met by this project, by this application. They would not give us a permit unless we met those rules. And the important distinction I'm making is that there's really 2 rules to pay attention to here. There's the 7:13 for flooding and the 7:8 for stormwater management. They're interconnected, they play together. Sheet 4. This is the cover sheet of the NJAC 7:13 Flood Hazard Area Control Act rules that were in effect when the DEP reviewed and issued a flood hazard permit for this project. This is nothing more than the cover sheet. This is the rule that they applied. The next sheet is page 11 of those rules, and is specifically the definition section where the highlighted text identifies how they define different kinds of flood hazard areas. And I am going to read it for everybody's benefit. There are two types of flood hazard areas. Tidal flood hazard area, in which the flood hazard area design flood elevation is governed by tidal flooding from the Atlantic Ocean. Flooding in a tidal flood hazard area may be contributed to or influenced by stormwater runoff from inland areas, but the depth of flooding generated by the tidal rise and fall of the Atlantic Ocean is greater than the flood of any fluvial sources. And, number two, fluvial flood hazard areas in which the flood hazard area design flood elevation is governed by stormwater runoff. Flooding in a fluvial flood hazard area may be contributed to or influenced by elevated water levels generated by the tidal rise and fall of the Atlantic Ocean, but the depth of flooding generated by stormwater runoff is greater than the flooding from the Atlantic Ocean. So there's very clearly two different kinds. There's not a third kind that mixes them together. The first kind, the tidal flood hazard elevation, is what applies to us. That was what was stated in the permit. So again, the takeaway here is that the flooding, the storm surge from the ocean is what's going to govern the flood elevation on this site, not the storm water that comes down. You don't add rainfall on top of the storm surge that comes into the ocean and say that's my flood hazard area. It's one or the other.
Mr. Weisner, that's because the tidal flood is so much greater than the rainfall, correct?
That's correct.
So it's the equivalent of an Olympic-sized pool and a bathtub. The bathtub doesn't change the level of the flood. Is that accurate? As an analogy.
That's accurate. The rising of the tide, the blowing of the wind, the increase of the storm surge is what drives the water to come up higher than any amount of rain will along the coastal area.
And the rain is immaterial.
For purposes of a tidal floodplain, correct. Rain is still going to happen, and you still have to manage it, which we've shown how we are managing it by keeping it on our site. But when the tidal flood event happens, no amount of rain is going to increase that tidal flood amount.
Which was my question, as far as immaterial, right? If the tidal flood event is happening, the rainfall, there's no impact from that because...
It's the ocean. It's a literal and figurative drop in the ocean.
Okay, go ahead, Mr. Weisner.
So moving on to page 6 of this presentation, this is just the cover sheet of the NJAC 7:8 stormwater management regulation that was in effect when the DEP issued the flood hazard permit for the project. So these are the regulations that DEP reviewed when they reviewed our application and issued a permit. Page 7 of this slide deck is page 4 of that rule. And what's highlighted is text from the scope and purpose of those rules. The chapter establishes design and performance standards for stormwater management measures required by rules pursuant to the Flood Hazard Area Control Act. So again, they're tied together. Flood hazard and stormwater, they're not to be taken separately. Page 8. These are still the 7:8 stormwater management rules. And this is on page 42. And the highlighted section is 7:8, 5.6b, or 5.6. I don't know why it keeps popping up. The stormwater runoff quantity standards. And section B, so this is where you have to manage stormwater that falls on your site. It provides 3 options under B, or actually it provides 4 options under B. In order to control stormwater runoff impacts, the design engineer shall complete one of the following. Number 1 starts on this page. I'll flip to page 9, which is the last item of this presentation. It continues on with 1, 2, and 3. I won't read them, but in summary, These are the options or the requirements to control stormwater runoff from rainfall at the property by either showing that you're reducing it, you're capturing it, you're releasing it more slowly, you're infiltrating it, you're managing it so that it doesn't run off your site. Option 4, highlighted here, addresses what happens in tidal flood hazard areas. So in tidal flood hazard areas, stormwater runoff quantity analysis in accordance with B 1, 2, or 3 above, that's the first 3 options, is required unless the design engineer demonstrates through hydrologic and hydraulic analysis that the increased volume, change in timing, or increased rate of the stormwater runoff, or any combination of the 3, will not result in additional flood damage below the point of discharge of major development. Highlighted in green, no analysis is required if stormwater is discharged directly into the ocean, bay, or the reach of any watercourse between its confluence with the ocean, bay, or inlet and downstream of the first water control structure. And the reason this is highlighted is because this is, in simple terms, what DEP relied on when they reviewed our flood hazard permit, as we are discharging directly to the tidal flood event. We're discharging directly through pipes and, frankly, through the flood that happens on Chapel Avenue to our site. The wet ponds have direct pipes to our site, so the stormwater goes directly to the tidal flood event. DEP validated this when they issued the FHA permit, the flood hazard permit, because we didn't provide an analysis of the stormwater that complied with 1, 2, and 3. They would not have issued the permit if they required that. So DEP relied on what's highlighted here in green, or I should say they interpreted it, and that's how they approved the project. And so analysis of runoff at the property line by conventional means with a stormwater basin or some what's my 100-year runoff, it does not impact, govern, or control the tidal flood elevation. The tidal flood elevation is what governs here, which is, again, the storm surge from the ocean. The last thing just highlighted there, Section C, that the stormwater quantity standard shall be applied at the site's boundary to each abutting lot. Again, the standards are referring to items 1, 2, 3, or 4. If there is no standard to be applied, no analysis to be applied, that section does not apply. Again, if DEP wanted to ensure, because they thought that this was fluvial controlled, this was controlled by rain, they would have asked us for an analysis at the boundary. They didn't. So, no analysis of the 100-year storm or future 100-year storm was required by DEP. However, we did it to show that we're capturing it and keeping it on site anyway.
We did it because the HOA asked us to do it, correct?
That's correct.
Okay.
The HOA also asked us to analyze runoff from the tidal 100-year event. As I hopefully have described to you, there is no runoff from the 100-year tidal event. The tidal event is the storm surge from the ocean. It's a flat elevation, elevation 12 in this case, and it fills anything that's below elevation 12, regardless of whether it's a property line, a fence, or anything else. The water comes in from the ocean, it hits that mark, and that's it. No amount of runoff is going to change that. So the site's in a tidal floodplain. That's what controls, not stormwater. What we have done, and I've described, we did an analysis of what happens under the future 25 and the future 100-year rainfall. And again, that's looking to the year 2100 to say how much more rain are we going to get, forecast that, drop it down on your site. And even doing all that, we captured the rain and kept it on our site, not flowing into the HOA. It was suggested maybe we should run additional pipes to the wet pond. Well, the wet pond has all this tidal flood influence that comes in and fills it up to an elevation. Adding more pipes is not going to change how much the tide comes in. It's not going to change how quickly we can get the water out. We've shown we can keep it on our site. Also, understand that there's a question or a concern over a couple of inlets. And these are the last points that I'm aware of. that were raised, and I just wanted to walk you through them. So if you recall from the project, there is an emergency access that's proposed at the end of Aurora Place of the HOA via easement that goes into the applicant's property. And again, because the applicant's property will be higher, there will be a slope. We made pavers in here, so it won't be paved. It'll be grass pavers, but if necessary, an emergency vehicle can drive on it. And at the end of that road, at the low point of the applicant's site, right where it meets the HOA property, is catch basin 408. And just to walk you through the detail for 408, I'm now on page 15 in my drawing set in this upper right corner. Catch basin 408 is a few feet inside the property line, so this right side of the figure where I'm circling my hand on the screen right now is the HOA property, and the applicant's property is on the left-hand side. This is the boundary line shown with the long and the long dash and the two dots. The inlet in question, the surface elevation of that inlet is 11.24. The property line grade is 11.39, so about 2 inches above. The inlet's 2 inches lower on the applicant's property. When we ran the 100-year storm event, rainfall event, we found that the water in the pipe in that inlet would actually be about a foot below the inlet surface. So it'd be about 10.28 compared to the surface elevation of 11.24 compared to the property line of 11.39. We understand the applicant would like more freeboard, or they'd like that inlet to be lower. That water elevation is already more than a foot lower than the adjacent property. It's not behind the retaining wall. It's frankly a little bit lower than the applicant's property, but there's more than the 6 inches of freeboard that they're asking for by our analysis and model. So physically lowering that is not going to change the hydraulics of the system. And moreover, all these elevations that I'm referring to, 11.39, 11.28, they're all below elevation 12, which is the tidal flood elevation. So again, we're talking about rainfall, where the bigger challenge or the more regulatory issue is the tidal floodplain from the storm surge. Likewise, we understand there's a question or a concern on near Freedom Way, which is down near Chapel Avenue. Just to zoom out, Chapel Avenue is running across the bottom of the page. Freedom Way is running north-south on the page into the project site, or into the HOA. And there are a couple of inlets. Again, the applicant's property is higher. It has to be higher to meet the floodplain regulations. And at the edge of the property where the applicant slopes down, we have a couple of small inlets there. Those inlets are at least 6 inches below the adjacent property elevation. They're about 18 inches below Freedom Way. So it does show in our model, under the extreme event that they asked us to run, that there will be water on top of those inlets. The water can't get through the inlet and can't get through the pipes quick enough under a rainfall event. But Freedom Way is still a foot or 18 inches above that. And moreover, that whole area, again, if I zoom in closer, the elevations are 9.3, 10.7, 9.54. Everything's below elevation 12. So again, the tidal floodplain governs over this area and will fill in, irregardless of property line, inlets, or anything else in a tidal storm surge event, which is what governs here. So I just wanted to explain those items to you because I think we've done our best efforts to address all the comments that we could. We've addressed all of them except for, I believe, these last couple. I don't believe that they will enhance the project any more than we already have. They're not required by the regulations. frankly, the tidal flood elevation makes all of these areas moot when you compare them to can it be 2 inches lower, 2 inches higher, or so forth. The project is compliant with the redevelopment plan, does not require any variances, waivers. This does not require any variances or waivers from any code that I'm aware of or the way we've designed the stormwater. And that's about it.
Stormwater, we've protected the HOA property from stormwater runoff, correct?
We have. We've shown under the extreme events of a 100-year storm, which you normally don't design your pipes and your inlets for. You normally design them for a 10 or 25-year storm. We've shown under a 100-year storm that there's still no water leaving the site to go over into the HOA.
So we have our flood hazard area permit from the DEP, and at the request of the HOA, we've run the modeling so that we can confirm what you just said in terms of stormwater runoff, correct?
That's correct.
Okay. I have no more questions for Mr. Wazer.
Okay, thank you. I have no questions for Mr. Wiesner. Anybody else? Thank you, sir. Council?
Jim, do you mind if I?
Yeah, sure.
This down makes it a little easier. Thanks. Like I said, I'm not big on paper, so. Good evening, Mr. Wiesner.
Good evening.
Couple of quick questions for you, and I'll try to be as brief as I can. One of the concerns, I think you said, raised by my client was the impact of flood waters on Port Liberté Homeowners Association's property, correct?
That's correct.
And that concern included the impact of tidal flood waters on Port Liberté's property, correct?
That's my understanding, yes.
And you state in your stormwater report that your changes did not address the impact of the 100-year tidal flood event, correct?
The 100-year tidal flood event is driven by the ocean, not by rainfall on our site.
And in your report, you state you did not address the impact of the 100-year tidal flood event, correct?
I don't think I agree with that.
Your report doesn't address the impact of a 100-year tidal flood event, does it?
Our flood hazard permit addresses the 100-year tidal flood event.
What changes were made to the plan to account for the 100-year tidal flood event between the prior iteration and the October 2025 iteration?
We didn't make any changes for the 100-year tidal flood event because the 100-year tidal flood event is a not rainfall driven event. The changes that we made were in response to the HOA's request to address rainfall events, not a tidal flood event. The tidal flood event was analyzed and approved by the DEP under the flood hazard permit.
I think you also said that NJAC 7-8, which I think you referred to as the stormwater management rules, those apply to the project, correct?
They do.
And those must be followed, right?
They do.
Okay. One of the conditions of approval for this application is that the applicant does not impact a neighboring site with floodwaters as a result of construction of its development, correct?
Is that read from a permit or?
Is it your understanding that one of the conditions of approval for the planning board to be able to approve this is that the applicant's application will not impact a neighboring site with floodwaters?
Objection. You have to specify whether it's.
You got to get in front of the mic.
I'm sorry. Thank you. You have to specify whether it's a stormwater event or a tidal flood event. They're not the same thing. So when you say flood, we need to know which one of them are you asking about.
Okay. Let's start with fluvial.
So the controlling flood event is a tidal flood event. So I don't think that a fluvial flood event is the applicable standard to be applied here. That said, our report and analysis shows that under a fluvial event, under the 100-year fluvial event, we will not be impacting the HOA.
Okay. And how about under a 100-year tidal flood event? Your report does not show that you will not impact the HOA, correct?
So the 100-year tidal flood event is the storm surge from the ocean that will seek out an elevation. We are not changing any elevations on the HOA property. So we are not changing the tidal flood event impacts on the HOA property from what it is today.
I want to turn to the pump station for a second. You talked about the January letter from JCUMA. It was A25, correct?
I believe so, yes.
Okay. And I don't know if you have a copy.
Oh, sorry, A25 is an October letter. Did you say January or October?
A26 is the January letter.
My apologies, I missed an exhibit. Okay. You talked about 826, the January letter from JCUMA, correct?
Correct.
Okay. And JCUMA states in that letter that one of the upgrades that JCUMA was going to carry out was to design, purchase, install, and permit a netting chamber.
That's correct.
Okay. And the netting chamber purpose was to prevent solid waste from entering the pump station from the project, correct?
Correct.
Okay. And you referred to that during your testimony as the clogging that began after the Oliver was built, right?
The netting chamber will, in the JCMUA's eyes, reduce or eliminate the clogging that is occurring, that they seem to have occurred after the Oliver came online. I don't have the knowledge that the JCMUA has in terms of all the specifics, but that's my understanding.
Okay. And the letter said that Pulte will reimburse 33% of the costs for that netting chamber, correct?
That's correct.
Okay. So letter states first, JCUMA will pay, and then Pulte will reimburse 33.33% of that cost, correct?
That's correct.
Okay. The letter doesn't address whether or not Port Liberté will incur any cost from this requirement, correct?
I don't see it.
Okay. But you have an understanding that subsequent to the issuance of this letter, you learned, because you testified to it, that JCUMUA is now seeking to require Port Liberté to share in the cost of the netting chamber, correct?
So, yeah,
Is that an objection, counsel, or?
yes.
Okay, what is the objection?
Here's the point.
No, not the
No,
point. What's the objection? That's a question posed to a witness. What is the objection?
Objection is we don't exactly know what the JCR.
Stop the we. The witness testified. There's a question pending to the witness. What is your objection other than you don't want your witness to attempt to answer the question?
He can attempt to answer the question. I'll withdraw the objection.
Thank you, counsel.
I don't know what JCMUA is going to charge or who they're going to charge for the other 2/3 of the cost.
And you heard your attorney say that they were going to charge the Oliver and the Port Liberté community during your testimony, correct?
I heard that statement.
I don't have any further questions for the witness at this time. Thank you, guys.
Okay, thank you, counsel.
Mr. McCann?
You know, I'll withdraw what I said. The point of the letter.
I wanted to know if you had any questions for the witness.
No, I'm done
All right,
questioning the
so
witness.
hold on one second. Ms. Hagianis.
Ms. Hagianis?
Someone say that's inappropriate.
Okay, good evening. You had testified that your project site is going to be higher than the surrounding sites. How much higher?
The project site, in accordance with the flood hazard area permit, has to be raised to at least 1 foot above the flood elevation. The flood elevation is 12, so the site will be raised to at least elevation 13. the surrounding properties vary in elevation. Some are below 13, some are above.
How far below?
Well, the Freedom Way is at elevation 8 or 9.
Okay, so there might be a 5-foot difference in elevation between your project site and the surrounding parcels.
There's several feet. That's why we have a retaining wall along some of the common boundary. But we're not proposing to change any of the grade on the adjacent parcels, but we are trying to make this site making this site compliant with the flood hazard regulations and elevations.
Okay, and I actually had a question about the master plan amendment. I don't know that Langen prepared that. I don't know though if there's a different witness that I should ask that question to.
In fairness, Mr. McKenna, I don't think we got into the master plan amendment yet.
That's the next case.
Okay, all right, thank you.
But actually, based upon those questions, we have an exhibit.
You have to stand in front of the mic. I don't mean to be.
Based upon that question, we do have an exhibit that can show the board the differences in the elevation between the HOA property and this property. Brian, do you want to pull that up? Might help clarify some of the questions.
I'm worried that I already said A27 was my last exhibit.
You did say that. You also said you were going to be quick.
Shall I describe this exhibit?
Yes.
So this is going to be A28.
A28. Tidal Floodplain Extents Exhibit, prepared by Langen, dated 3/10/2026. And if I can explain what we're looking at here, you might recognize the shape of this property of Lot 15. The unusual shape, I'm tracing with my hand. Chapel Avenue is on the bottom, running in sort of a 7 o'clock to 2 o'clock angle across the page there. And what's highlighted in blue is the tidal flood elevation extents that come in from the Hudson River and inundate any areas that are lower than the tidal flood event elevation, which for most of this map is elevation 12. The further you get out on the point, the elevation does get higher. It gets up to elevation 13. This map has been put together from a combination of our flood hazard area permit, plans for the adjacent projects, as well as flood hazard mapping from FEMA and other sources. So this is our best composite as to where the tidal flood elevation inundates land on and around this property. And what you can see is there is a small portion of our property down near Chapel Avenue and over at the emergency access that I had talked about before, where Catch Basin 408 resides, that is lower than elevation 12, and therefore it would be inundated under a tidal flood event. And what you can see is Chapel Avenue in this stretch is all inundated, as is Freedom Way, as is, if I could read this, Independence Way, Constellation Place, Aurora. This is existing mapping using existing topography. This is not because of our project. This is how the tidal flood event affects the low-lying areas that exist today.
So this is prepared by extrapolating different data from different places?
That's correct. Starting with the FEMA map, adding in our project and our topography, and marrying it up with the topography as best we understand it for the adjacent properties. Because the FEMA map's not 100% accurate. It provides an elevation, and then you apply it to whatever the topography is. But as you can see, there's quite a bit of tidal flooding around this site. And again, that will not be affected in any way by this project.
But the map only shows elevation 12.
It shows 12 at our driveway and at Freedom Way. You'll notice in the white text the flood elevation changes according to FEMA. It's elevation 13. It's actually 13 over here on the right-hand side at the inlet near Independence Way.
I guess my question is,
Only the areas in blue are below elevation 12 or 13. So only the areas in blue get inundated under a tidal flood event. A 100-year tidal flood event.
And is the flooding caused by the Pulte Homes would the flooding be caused by the Pulte Homes development?
No, this is the flooding caused by the storm surge coming in from the ocean.
What was the exhibit? I apologize.
number?
Yeah. Sorry.
28.
28.
Where is it? Where'd that come from?
They just pulled it out of their pocket,
Okay. Not on the floor. Okay.
not on the portal.
Gotcha.
Never seen before.
Now that we've seen this map, I did have a follow-up question.
I'm going to allow it. Chair, you don't have a problem with
No,
that, do you?
of course not. As long as it's on that mic.
Okay, and I guess I don't really have a frame of reference for this, and I'm not an engineer, but where if you weren't building anything and you weren't altering the site elevation up to 5 feet beyond what it is now, where would the water go?
All the blue that's highlighted would still be blue and the water would still go there. Any portion of the site that was below elevation 12, which was the majority of the site, would also be blue.
Okay, and would that alter where else the water? I mean, if a lot of water is flowing onto the Pulte site the way it is now during the 100-year storm event, would that mean there'd be less flooding in other areas of Caven Point?
Well, again, from a tidal perspective, the tidal flood elevation coming in from the ocean is not going to care if this site, if the HOA site, if any of those sites are filled above or below. The amount of water is so enormous, you don't
Okay.
change the flood elevation around the other sites.
Okay, got it. Thank you.
For the record, this was not part of our presentation. This is offered as a rebuttal exhibit based upon the questions that we received
That's
from
why I
the
allowed
HOA
you to
council.
show it.
Thank you.
Council, anything?
I don't have anything further other than we'll need a copy of this.
Sure, of course.
It's not something our expert has had an opportunity to review and consider, and then we'll address it.
Council, we need you on a mic when you talk.
Sorry. I made that mistake.
I heard you, but I don't know that.
Okay. I don't have any other questions other than making a statement on the record that we do need a copy of the document, the exhibit A28.
Yes.
So that we can review it and consider it and talk to our
Absolutely.
expert about it, which
Sure.
we'll do.
Thank you, council. Other council, you're
The
going to
mic.
do that. You're going to circulate this.
Yes, I will.
Going to actually upload it on the portal.
I will do that.
Anything else for this witness, Mr. McCann?
No, Mr. Chairman.
Do we have any questions?
I don't think so. Does anybody have any other questions, Mr. Wisner? Okay. Thank you, sir.
Thank you.
Council, where are we headed next?
Home.
Time is 10 o'clock. I don't want to break in the middle of testimony. I don't want to end the meeting in the middle of testimony. Just to keep a record clean. We're obviously, we'll probably have new board members coming on board during the rest of this application.
So let's deal with some of the housekeeping.
Yeah.
What the chairman's trying to tell you is we're not going to call the next witness. We're going to stop with this witness, right?
I
You all
got-
got that.
I got that.
He's a little more blunt than me.
You have a planner,
Yes.
and that is your last witness, unless you need some rebuttal witness to council's witnesses.
Yes, sir.
Okay. Council,
Mr. Cavallar.
Sorry.
Mr. Cabular. Microphone.
Get to the mic.
I'm going to make them put a mic at that table for you.
That would be great.
I'm lying. I'm not going to do
No,
that.
we're not going to make him do that. No
Should.
money for that.
I'll steal one of these. That kind of. So I will have an engineer, Ms. Wong, who's here tonight, and a planner, Mr. Pesolano, who I plan to call. In terms of how much time I need, maybe an hour for both of them. Not total. I mean total, not each.
Okay.
15 minutes for the planner.
Who's your planner? Mr. Moronsky?
Yes.
And I believe you.
He does talk fast. I've noticed that.
Ms. Hagianis, can we get you on a microphone as well?
Thank you.
What do we think? Do you have witnesses you're going to be calling?
Well, I'm kind of trying to catch up. I'm coming into this at like the 10th hour.
Of course.
So I'm may be getting a planner on board. His name's Carlos Rodriguez, but we haven't even engaged him yet.
Okay.
So then that's got to happen. He's got to come. He's got to be prepared, right?
Yeah. We won't
So-
we won't ask for a continuance if he's not here when it's the planner's turn to testify. We'll be finished.
Okay.
So, Chairman, as you know, I got a love letter from Mr. McCann that said the end of May, that's it. It's over for me. He's going to break up with me. So, Mr. McCann, have you reconsidered?
Well, there is a meeting before the end of May.
Mr. Harrington's got a lot of things on that meeting.
Well, he didn't give you a love letter.
And he wasn't willing to move some of his for you. I thought that was weird, but be that as it may. So is your position you are not prepared to extend the time in which the board has to act at this juncture?
My position is yes. We're not. My position is we're not willing to extend the time past May.
Cam, here's what we're facing in terms of the calendar. May 12th, which is the next meeting. And then the following meeting in May is the day after Memorial Day. Because that was a good idea.
There's only so many days that we can reserve this room, but May 26th, we can make it work.
Presuming people are back from the holiday weekend.
Okay, appreciate that.
So,
Cam, I will not be here that date. Just for the record.
Understood.
I know, you give me that eyeball. It's not negotiable. It's not negotiable. Apologies. Okay. So Cam, what can we carry to at this point?
We can carry this item to May 26th with preservation of notice.
Can we carry it to the 12th so we can entertain a discussion tomorrow?
We can definitely do that.
Council, I'm saying for the record right now, we will not hear it on the 12th, but I don't want to pin down notice to the 26th until we can regroup and have a conversation about scheduling.
in terms of what's going to happen if we're going to move it from the 26th, right? It may require some kind of noticing or something
So,
after the 12th, right? If we show up on the 12th and decide something has to give, There won't be time to notice is all I'm suggesting.
Well, where I'm going with this is, do we need a special meeting? So I don't want to lock down the 26th as the next meeting, or carry it to the 26th if we can get a special meeting maybe on the 19th.
That would require planning with directors and staff, and we obviously see if we can secure the reporting services. So
Of course. And I don't know what kind of time frame we need for that. Because my understanding is we also go to a virtual meeting starting in June.
that is correct.
I cannot imagine doing this on a virtual meeting. That is a disaster waiting to happen. There's too many moving parts here. As we know, as we've talked about ad nauseum, online meetings take longer. As much as the kids might think they're quicker, they're not. It's going to be longer. So, we're I don't know.
So, Mr. Chairman, are you saying carry it to May 12th with preservation of notice? In the meantime, you would be willing to try to organize a special meeting for the 19th, which,
I'm willing to have that discussion tomorrow.
if you were to successfully do that, we would have to notice.
You have to notice, no question about that.
Even
And
if
then
we,
show up on the 12th, just talking this through, show up on the 12th and carry the case to the 19th when the special meeting is to occur.
The answer is, yeah, that's what would have to transpire.
okay.
And
That's why I'm not a lawyer.
the,
Well, that's okay with the applicant.
So wait, they would have to notice?
yeah, because
the
we've
19th.
now we've created a meeting date. It's not a regular meeting. We've put it on the 12th. And now we're creating a new date that nobody would know about until we've determined it, and then we got a notice for it.
Okay.
So,
So with that said, I guess we're looking at the 26th, right?
I understand what you're saying.
if we don't have the ability to determine the special meeting date now, which we don't, right?
We don't.
So, that's where we're at. Mr. Caliber? How is your witness and availability?
We're good.
Both the 12th, 19th, and 26th.
Surprisingly, I have nothing to do.
Amazing.
That is
So
very
sorry.
unusual, but
My planner's not available on the 19th.
Okay.
Should we hear
Put a
from the
leg with
planner now and then move the rest to the 19th, or is that not allowed?
I don't have my planner right now.
Right, but he wasn't here anyway. The bigger issue is we got to get out of the building.
Yeah.
And
Yeah, we have a
resolutions.
hard stop at 10:30. We only have security so long every night, so hard stop is 10:30.
So you can't have a special meeting on the 19th because your planner's not available. Kind of puts me in a funny position.
It's the 26th.
Take a couple of seconds.
May I have 30 seconds?
Yes.
Sure.
5 minimum.
If
Go
the,
ahead, Counsel.
if the board is still willing, we'll agree to the 19th. Will somebody else from the Langen Group, who's a professional planner, will testify in Sean's place?
So I don't know that we have the 19th.
I know.
That's the problem. That's why I was saying carry to the 12th, so we can have a conversation tomorrow, see if we can get the room, see if we can get it.
Which is what we're going to do. We're going to
I'm
carry
okay
to the
with that
12th.
still.
Here's what I'm suggesting, Chair. We carry to the 12th. If we can make the 19th happen in conversation with staff tomorrow and by the end of this week, then Mr. McCann can get the notice done. And that special meeting can happen on the 19th. If it turns out that we can't get the room and the special meeting can't happen on the 19th, he's at the back of the agenda on the 12th. He may or may not get reached. People are going to have to show up. They're not going to be happy, as we know. And they may not get reached, and they're on the 26th. Presumably at the midpoint of that agenda, with the understanding that we only got an hour and a half of testimony and then all of public, if we have a quorum.
That all could work.
Could.
We theoretically.
Mr. Cavalier, is your engineer available on all of these dates?
We're fine on all the dates, yes.
And planner. Ms. Hajianis?
And your planner?
Yes.
Took a bite of something right as you asked me. It's a long meeting. Well aware.
I didn't even notice.
Okay, so we carry to the 12th.
That's the game plan.
And we'll have a discussion tomorrow and see what we can put together.
Thank you, all, as always, for all of your time. Appreciate it.
Okay, so at this time, we're going to carry this to the, May 12th. Do we need a roll call for this? Okay. All right, so let's move on to memorialization of resolutions, please.
Chair, I have 9 resolutions. Resolution 1, Devon Property Co. LLC for preliminary and final major site plan amendments, 3 New York Avenue, Jersey City, New Jersey, Block 6001, Lot 36, case number B2025-0233.
Can you hear my?
Applicant is.
Hold up one second. If
Could
we can,
everybody-
everybody, can we move conversations outside, please? We still have business to take care of tonight. Thank you, everybody. Thank you for coming.
Grove Street Partners LLC for extension and preliminary and final major site plan. Approval 659 Grove Street, Block 6002, Lot 8, case number is B2026-0033. In the matter of Kennedy Boulevard Acquisition LLC, address is 2859-2873 John F. Kennedy Boulevard, Block 10601, lots 43 to 48. Case number is B2025-0129. April 14, 2026, Journal Square 2060 redevelopment plan area, Zone 3, Commercial Center. Application for preliminary and final major site plan approval with deviations. City of Jersey City approving preliminary and final major site plan for 500 Washington Boulevard, Block 7302, lots 52 and 53. Approving minor site plan, case numbers B2026-0037, submitted by New Singular Wireless PCS LLC, 2854 John F. Kennedy Boulevard, Block 10602, Lots 8. Approve in the matter of Paramjeet and Jaijit and Achint Singh. Applicant number is P2025-0150 for minor site plan approval. In a matter of 792 Communipa Holding LLC, applicant, case number is P2024-0212, address for major site plan approval and use and conditional use approval. 186 Terrence Development LLC, acquisition application P2025-0166, decided March 31st, 2026, for minor site plan approval with C variance. Resolution for the Planning Board for the City of Jersey City, case number P2024-0604, for preliminary and final major site plan approval. Abraham Fayed's address is 103, 105, 107 Monticello Avenue, Block 17906, lots 25, 26, and 27.
Okay, do we have a second, please?
Second.
All right, Cam, could we have a roll call?
Commissioner Wick,
Aye.
Councilwoman Little,
I'm so sorry. This is my first planning board meeting that I am on the planning board for. What are we voting on? What exactly are we just acknowledging?
Yes, these are past resolutions, past cases that we've heard. We're memorializing these resolutions.
Okay, so it's like approving the last meeting's
If you want to
minutes.
recuse on it, we have quorum if you want to recuse.
Because I was not here last meeting.
Sure.
Okay, thank you. Yeah, I will recuse.
Same with me.
Same? Okay.
okay, so 2 recusals, and Commissioner Kaplan,
Aye.
Commissioner Patel. Actually, I didn't start with Acting Vice Chair Gongadin.
Aye.
And Chairman Langston. Okay, 5 in favor, 2 recusing, motion carries. The resolutions are memorialized. Thank you.
Okay. Adjourn and go off. Okay. All right, motion for adjournment? Anybody? Motion?
Second.
All right, motion and seconded. We are adjourned.